State of Ohio versus Aaron Cluxton, 25 CR 009. Charged for the state, Assistant Prosecuting Attorney Adam King, present on behalf of the defendant, his attorney Dennis Kirk, and are you Aaron Cluxton?
Yes, Your Honor.
All right, the defendant has entered a plea of guilty to illegal conveyance of weapons or prohibited items onto the grounds of a detention facility. That's a third-degree felony. The court ordered a pre-sentence report, and I reviewed the same. Have each of the attorneys had an opportunity to review a summary?
State has, Your Honor.
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the plea agreement. Looks like my client has been assessed for drug court. I did see a letter dated March 31st from the probation department indicating that she would be approved if the court would grant her request. She is currently compliant with her pretrial supervision as well as her supervision in Claremont County. She also has been assessed by REACH and is currently working with REACH as well as FRS to establish transportation to begin attending counseling at REACH. So would ask the court to follow the plea agreement.
Anything you'd like to say, Ms. Cluxton, regarding sentencing?
No, Your Honor.
The issue of drug court is something that is voluntary. The court doesn't order people into the drug court. The reason for that is that it's a more intensive program that's designed to do more than just keep somebody out of prison like probation or community control. It requires a lot of effort. There's a lot of responsibility. And I know you've applied for that. Is that what you want to do?
Yes, Your Honor.
Are you tell me that just because you think that's what's going to keep you out of prison?
No. So when I was released from River City, I didn't have much accountability, and only being sober for 9 months and coming back out into the quote-unquote real world, it is hard struggling. And I feel like, having someone to hold me accountable and being able to get in productive activities and being held accountable to have a job, because most of the time I'm not good with probation. So I just want to take this opportunity to actually get my life back together, go back to school, and I can get all the help I need through them.
Well, I agree with all that. Here's the reason I asked that question. In your assessment, the question was, on the form that I received, was presenting condition, and states, basically, why were you there? And it states, the client states, honestly, because probation is making me. I just did 6 months of CBCF. I guess they want me to have aftercare. And it says, would have been stressors, and you've said lack of motivation. What bothers me about that statement is this. If you go into drug court, because again, we don't make anybody go into drug court. I can put you on community control, try to keep you out of prison. That's the goal, and hopefully you'll succeed. Drug court is a much bigger responsibility. Daily call-ins for drug testing, programming all the time. If you relapse, you're probably going to go into a residential treatment facility. So it's a much broader approach. There's support for job training and education and other things, helping you with various things. And I think you'll benefit from it, but I'm questioning your commitment.
The statement wasn't really towards drug court. She had asked me about aftercare, and she said, how do you feel about being like an aftercare after being there? And I said I wouldn't have probably came to aftercare myself after being in River City. I probably would have done like meetings. So it was kind of more of like I came to aftercare because probation asked me to.
So you do want to be in drug court?
Yes.
All right. Well, then the court will accept your application. You have met the criteria, and it's ordered that this case be transferred to the drug court docket, and it's ordered that you be placed on community control for a period of 3 years under the terms that are in that program. You've signed the program description. You've got a copy of them. All the conditions and that are described and provisions in the program description are incorporated and are part of this order. I'm going to highlight some of the major ones, but if I don't mention them, anything that's in that document that you signed that's filed with the court is included. You'll be required to obey all laws with all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements that you make to probation and your treatment team. You keep your probation officer advised of your residence, place, employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you on your person when you're out of state. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone as an inmate or prisoner in any of those facilities without prior permission. You may not purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, weapon of any other type. To do so would be a violation of both federal and state law that could subject you to being prosecuted for a felony. And you're not to have any of those while under community control in this case. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance, drug abuse that has effects similar to those, unless you have a lawful prescription, and you must provide a copy of that within 24 hours to the probation department. You may not obtain a medical marijuana card filed in the drug court docket, and you must submit to drug testing when and as requested. You're not permitted to purchase, possess, or use, or have under control any alcoholic beverage, or be present in any places where those are sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who is a co-defendant in this case, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless approved in writing by your supervising officer. That applies to any family members that could fall within that definition, unless you're living with them immediately before the commission of this offense. You're not permitted to marry or establish cohabitation, a common law marriage type relationship with another after this date without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records or your ability to pay any fees, costs to be reviewed. If you're referred for an evaluation or assessment for any kind of treatment, therapy, counseling, training, or other programming, you'll submit to the evaluation or assessment. If there's any program indicated, you'll enroll in and follow that during the pendency of this action. You'll be required to pay the court cost and make payment arrangements to do that. You'll be required to comply with all of the conditions of the program and your treatment program in particular. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, your vehicles, or any other property or place that's under your control where you're found anytime by any officer of the probation department. And you'll sign a written acknowledgement of that consent to that. There'll be no fine or court cost or driver's license suspension imposed. I'm sorry, no fine imposed. Court costs are imposed. The court costs are a substantive order, and if you fail to pay those, in addition to being a violation of your community control, the clerk could also then collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have, including collection agency. And if that occurs, you'd have to pay an additional 30% for the cost of the collection on top of the cost. If that doesn't collect it, you could also be ordered to do community service in this county and be given credit for each hour you worked and an hourly rate set by the court each hour you worked to reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you are not compliant with the conditions, they'll file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can terminate you from the drug court docket, revoke your community control, impose a sentence between 9 and 36 months, a fine of $10,000. And if you have, as one of your violations, committed a new felony and receive a felony prison term in that case, the sentence imposed in this case could be ordered to be served consecutively to the sentence in that case. If that occurs, the law provides that upon completion of your prison term, the adult parole authority may put you under post-release control for a period of up to 2 years. They don't have to, but they can if they do. You'll be supervised on the terms they set, and if during that period of time they determine that you've not complied, then they can return you to prison and make you serve an additional period of up to 9 months for one violation, up to a maximum of 1/2 of your prison term for all violations. However, if you committed a felony under post-release control, and in addition, whenever sentence a judge in the new case could impose, that judge could also sentence you for committing that offense under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right, that completes your case. You're no longer under pretrial supervision. You'll be under the new conditions. You report to the probation department so that they can make an appointment for you to be transferred over to the drug court docket supervision with Officer Park. Anything further, counsel?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Yeah.
All right, this is case number 25 CR 34, State of Ohio versus Michael Carson. We don't have Mr. Williams logged in yet. So, first
Okay,
off.
well, he sent me something this morning, when I put in the dog, so he knows about it.
Okay.
I can email him.
Yeah. This is a sentencing being conducted by Zoom. Mr. Carson is appearing from the institution, or from this facility at the Highland County Justice Center. His attorney is Catherine Hapner. The state's represented by Prosecutor Collins, here from her office. Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person hearing?
Yes, we are.
And you're all right with that, Mr. Carson?
Yes, sir.
All right. All right, Mr. Carson has entered a plea of guilty to 2 counts of aggravated trafficking and methamphetamine, both third-degree felonies. The matter was referred to the probation department for a pre-sentence report, which I have received. Each of the parties had an opportunity to review an assessment?
Yes, I've reviewed it. Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Your Honor, we would ask the court to follow the joint recommendation. We would note that when we made the recommendation, we were going to stand by that, but we were unaware that the defendant had any prior felony convictions. Apparently, none of those are reported on his CCH.
You were unaware he had felony conviction?
Yes, they were not on his CCH.
Oh, okay. All right, anything further?
No, Your Honor.
Let's see, the restitution in this case.
It's $120 alone and $180 several.
And 180 joint several?
Yes, with Stacy Thacker.
All right, Ms. Sapner?
Thank you, Your Honor. We also ask that you follow the recommendation. I have discussed with Mr. Carson STAR program. He is ready, willing, and able to enter. My understanding is that there is a bed available for him in just a few days. And I've also just discussed the restitution and the meanings of joint and several. So we do ask that you follow the recommendation, and I believe that he will be a good candidate for community control.
All right, Mr. Carson, is there anything that you would like to say?
Sir.
Well, according to the pre-sentence report, you have, I believe, 12 previous felony convictions. Appears that all of those were in Escambia County, Florida, over 10 years ago, but they were all committed in a relatively short period of time, apparently, because all the convictions were entered on the same date, January 16, 2014. Looks like he had a total of 56 months in prison. All of those are relating to property crimes, stolen property, fraud, receiving stolen property, apparently, or dealing, as they call it down there, false ownership for pawned items. So those are all theft offenses. So it appears this is your first felony drug conviction. Beyond that, there's some traffic offenses, but nothing since 2014 that's been shown in the record. So given that that's the state of the record, the court will follow the plea agreement and sentence you to a term of 3 years of community control under the supervision of the probation department under these conditions. You must obey all laws of all jurisdictions, conduct yourself in law, body, manner at all times, report when and as directed, be truthful in all statements you make to the probation department. You must keep them informed of your residence and place of employment at all times, may not change either without prior permission, may not leave the state of Ohio at any time without prior written permission, may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate in those facilities without prior written permission. Because of your conviction, you're prohibited under both federal and state law from possessing, owning, using, or purchasing any firearms, ammunition, dangerous ordnance, and if you do so, you would be subject to being prosecuted for a felony in both state and federal courts. It's also a condition you not have any of those items while you're under community control in this case, nor any other weapons of any other type. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug of abuse, CBD, oil, kratom, or variant or analog of any controlled substance that has effects similar to those or drugs of abuse, nor may you possess or purchase or have in your possession any instrument, device, or thing that may be used to administer drugs or prepare them for administration or use, unless you have a lawful prescription for both the device or equipment as well as the substance. And you must provide copies of those to your supervising officer within 24 hours of receipt. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. Not associate with anyone who's a co-defendant in this case, nor any other person who has a criminal record as a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense and violate these conditions. You may not, after the date of this order, marry or establish cohabitation, a common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed and restitution. If you are referred by the probation department for an evaluation or assessment for any treatment, therapy, or programming beyond that ordered by the court, you'll submit to that, and if there's a recommendation for that programming, you're to enroll in and successfully complete that. You pay the court costs of this action and make payment arrangements to do so. You'll be required to perform 400 hours community service, a rate of 20 hours per week for 20 consecutive weeks, unless you're working at least 20 hours a week or a full-time student, or you have documentation by a physician or prior disability finding that you're unable to perform that service. Now, you're going to be required to successfully complete the STAR program and aftercare that's recommended. There's a bed available for you on April the 16th, so you'll be held in jail until you're conveyed to STAR on that date. Now, the requirements that you complete STAR is a 100% complete requirement. You don't get credit for 75 or 80 or 90%. It's 100%. And if you do not complete it, then the court's policy is that prison term is to be imposed. You're also required to complete any aftercare they recommend once you've completed the STAR program. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your vehicles, your residence, or any other property places under your control where you're found at any time by any officer of the probation department. There'll be no fine or driving suspension imposed. You'll be required to pay restitution in the amount of $120 alone and $180 joint and several with your co-defendant, Stacy Thacker, to the Hinds County Task Force through the Victim Restitution Escrow account, and you'll be required to pay any fees that are charged for that service. You'll be required to pay the court cost, and if you fail to pay court cost or make payment arrangements and continue to pay the court event plan, then the clerk of court can collect it through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, it could also be referred to a collection agency, and then you'd have to pay an additional 30% on top of that. If that doesn't collect it, then the court could permit you to do community service above that ordered in this case, and you'd be given credit for that community service in an hourly rate set by the court for each hour you work. Each hour you work will reduce your judgment by that amount until paid full. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court, give you a copy. There will be a hearing. If the outcome of that hearing is that you failed to comply, then at that time the court could revoke your community control and then sentence you to between 9 and 36 months, 9 and 72 months in prison and fine you $20,000. If that occurs upon completion, and if that occurs because you have been convicted of another felony while on community control and you receive a prison term for that, then the sentence imposed in this case could be ordered to be served consecutively sentenced in that case. Now, if that happens, once you complete your prison term, the Adult Parole Authority does have authority to, upon your completion of your sentence, place you under what's called post-release control for a period of up to 2 years. If they do, you'll be supervised under the terms they set, and if during that period of time they determine that you failed to comply, then they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half your prison term for all violations. However, if you commit a new felony, in addition to whatever sentence is imposed by the judge in the new case, that judge is also authorized to sentence you for committing an offense while under post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively as sentence in the new case. All right. Is there anything further, counsel?
No, Your Honor.
No, Your Honor.
All right. You'll be held in custody until you're conveyed to STAR. Mr. Carson, thank you. All right. Case number 24 CR 172. Mr. Belial is appearing. Are you, Gene Belial, appearing there from the jail?
Yes, sir.
All right. Mr. Belial is represented by Jacob Wagner, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins, on behalf of the state. Defendant entered a plea of guilty in this case to, I believe, unlawful sexual conduct with a minor, a third-degree felony. The court did order a pre-sentence report, and I have received that. Each of the parties had an opportunity to review a summary.
The state has, Your Honor.
Defense counsel has, Your Honor.
All right. Ms. Collins, has the victim of the offense or representative been notified of the time, place, and purpose of this hearing, the right to be heard?
She has, Your Honor.
All right. Thank you. All right. Now, Mr. Belial, before we proceed with the sentencing, I need to inform you of the duties that you will have to register as a sex offender or child victim offender due to your conviction in this case. You are hereby designated as a Tier 2 sex offender, child victim offender registry under the law. Now, what that means is that you'll be required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if you're temporarily domiciled, in other words, staying there for more than 3 days. You're required to register in person in the sheriff of any county in which you may establish a place of education immediately upon arriving in that county. And you're also required to register in person with the sheriff of any county in which you have become employed and are working more than 3 days in a row or 14 days in a calendar year. If you are going to be living in another state, which it appears you would be living in the state of Kentucky, then you'd be required to register either with the sheriff of the counties that I just described, if the sheriff is the one who maintains those records or registries, or if it's under a different public office, then you would have to register with the appropriate public official who's charged under that state law for maintaining registry, sex offender registry records and supervision. If you change your residence, then you are required to notify the sheriff of the county in which you're going to be moving into of that change at least 20 days before, if it is going to be a place of education or residence. If you are going to a different county for employment, you have up to 3 days to register, and then after that you must register in that county. If you become, if you no longer have a fixed address and don't have a permanent residence, then you must provide a detailed description of the place or places that you're going to be staying, and then not later than the end of the first business day after you do obtain a fixed address, you must register that with the sheriff of the county in which you're living. You're required to provide the sheriff with temporary lodging information, including your address and length of stay, if you're going to be absent from your county of residence for more than 7 days, for 7 days or more. So like if you're going to be visiting family or on a vacation, or if you are going to be in a hospital in a different county, then you need to notify of that. You're also required under federal law to report any international travel to the registering authority at least 21 days before that occurs. Failure to do that is subject to a criminal prosecution under both federal and state law. You're required to provide written notice within 3 days of any change in any vehicle information, email addresses, internet identifiers, or telephone numbers that are registered to or used by you to the sheriff of the county with whom you most recently registered. Now, your registration period will be for 25 years once you are released from custody. and you'll be required to verify the information with each county in which you're living, working, and going to a place of education if applicable, at least every 180 days. In your verification period, you cannot verify any earlier than 10 days prior to that date. And that verification must be in person. It cannot be by Zoom or phone or mail. You have to do it in person. And according to the information, it appears that your residence is in McCracken County. Is that correct?
Yes, sir.
And so upon your release, if that's where you're going to establish your residence, then within 3 days after you are released from custody, you must register with the sheriff's office there. That looks like it is at 300 Clarence Gaines Street in Paducah, Kentucky. Now, if you fail to comply with any of the requirements that are imposed upon sex offender child victim registrants, that would subject you to being prosecuted for a felony, either in this state or in Kentucky, and you could be subject to being in prison for those violations. Now, I have here the original form, and it looks like there's a signature here of Gene Bilal. I'll hold that up to the camera. And is that your signature there?
Yes, sir.
All right. Did you just sign that this morning?
Yes, sir.
All right. I'm going to put the date on it since it's not on there. And then below that, I'll sign to confirm that you were informed of these obligations on the record. All right. Mrs. Collins, anything on behalf of the state?
Your Honor, we would ask the court to sentence the defendant to a term of incarceration of no less than 4 years. We would note that the defendant has 27 prior felony convictions, and while none of them are a sexual assault or allegation of sexual assault related felony, this obviously is. We would also note that this crime occurred in 2008, so the law as it stood in 2008, unlawful sexual conduct there was no high tier, low tier, as the court knows. That became effective in September of 11, so this would be a 1 to 5 year prison sentence rather than a 60-month prison sentence possible. This case took so long to solve because while DNA was collected immediately after the commission of the offense, it was not tested until after he was recently convicted in Kentucky of a weapons charge. And once that happened, they collected his DNA, they compared it to the DNA that we had from 2008, and that's how a match was made. And we have discussed this case at length with the victim in this matter, and she agrees with the outcome of this case being an unlawful sexual conduct with a minor. Based on all that, we would ask the court to sentence the defendant to a term of incarceration of 4 years. Thank you.
Mr. Kirk? Mr. Wagner?
That's right. Your Honor, I'm not quite sure where to begin. We would ask the court to not follow the state's recommendation. Your Honor, I can say with a straight face, I think community control would be an appropriate sentence in this case. Don't disagree with Ms. Collins, what she said as far as my client's prior history. And getting to know Gene throughout this case, Your Honor, and actually again going over sentencing today with him, up until 2008, Gene openly acknowledges he was far from a model citizen. He can tell you maybe a little bit about his history, but he had an important impact in 2008 that changed his life, and I admire him for that. With that being said, Your Honor, again, this case is about 17 years old. In looking at it, I do not condone the conduct, but I do think it's interesting that there's no prior same or similar acts, at least that I see, that indicate this is a pattern of anything that happened. I guess I'm going through or making the presumption or assumption, Your Honor, this is just a horrible choice on my client's behalf, and we would ask the court to consider the fact that this is not a repeat behavior on his record. Again, I know Gene does want to address the court, Your Honor, but I do know, Your Honor, he is gainfully employed. Should he be released here today or put on community control, he's got about 5 months down in time, Your Honor. But throughout this case, in the original interrogation, he did deny culpability, as a lot of people do. But throughout the case, though, he opened up, admitted his full acts in this. While do I feel it's necessary of 4 years, I do not. Your Honor, I would ask the court for community control in this matter, and I know Gene would like to address the court.
All right, Mr. Belial, anything you'd like to say?
Yes, Your Honor. Your Honor, up until the middle of 2008, when I lost both of my parents within a week of each other, my life was filled with drugs and bad choices and constant trouble. I was always in trouble, as my record bestows it. But I was on the road to total destruction. But when I lost my parents, I realized I needed to grow up and not only be a better person, but also a better parent. Since then, I've changed my life around. I've quit drugs and alcohol. I raised my two oldest children by myself, even helped my daughter through the University of Kentucky. I've settled down, remarried, and am currently helping to raise our two minor children, one who has medical and mental disabilities, while maintaining employment this whole time. Yes, I made a lot of bad choices back then, to which to this day I regret and always will. But I have learned from these choices, and except for the misunderstanding on my part of thinking I had my gun rights restored last year, which was not the case, and I was put on probation, and I have stayed out of trouble and have complied with probation this whole time. I have become a law-abiding citizen and have stayed clean for the past 16 years. This one bad decision should not define who I am or who I have become, because I am not that kind of person. Did I know how old she was? No. Should I have asked her age? Most definitely. For that, I apologize. I apologize for making a decision that has changed the lives of all those involved. And yes, I should have made smarter and better choices. And if given the chance to be on probation, I will prove to this court and society that I am not a bad person, and this does not define my character as a person. And I thank you for your chance to speak, Your Honor.
All right, thank you. Well, I do note that you had several previous felony convictions in Kentucky dating back to 1985, and actually burglary and possession of a forged instrument also back then. And then the most recent one prior to 2024 was in 2008, a forgery conviction. Then you also have a currently on probation for possession of a firearm by a convicted felon, which is another felony. So that's, I think, what probably led here finally to your DNA being caught up in the system and getting a match. And while it's admirable what you've done in terms of at least staying out of trouble, as far as we know, no arrest since 2008, this is a serious offense. This girl was 14 years old at the time. That should have been evident. You picked her up, brought her across state lines, agreed to pay her for sex, then dumped her out in Walmart up in Fayette County and didn't pay her for the sex, and just went on about your way. So, you were exploiting this young woman, and, that is something that can't be tolerated. Good behavior after the commission of a crime doesn't, excuse you from being held accountable for that offense. And the fact that it's taken this long for you to be held accountable, it's not, I can't say that it's your fault because, you just went on about your business, but it took this long for the technology to catch up to you, and it has. And so it's, in the court's judgment, victims of sexual offenses and exploited children, offenses require a prison sentence. So it's a judgment order of the court that you be and are hereby sentenced to the Correction Reception Center in Orient, Ohio, for a period of 3 years. You'll be given credit for the time served, which I have here as of today, 138 days. Arrested on 11/15/24, is that correct?
November 5th, Your Honor.
On the 10th?
The 5th?
5th. All right.
November 5th.
Was that in Kentucky?
Yes, sir.
All right. So 10 days to that, so that makes 148 days of jail time credit. Now, upon completion of that prison term, it is mandatory that you be placed under post-release control supervision for a period of 5 years by the adult parole court. I'm sure they'll make arrangements for courtesy out-of-state supervision, but there is a process you'll have to go through to be able to get that transfer. If during that period of time you fail to comply with the conditions that are set forth in that order, or in those conditions by the APA, then they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term, which would be 18 months for all violations. But if you commit a new felony during the time you're under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, the judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. You're also ordered to pay the court cost, for which the judgment, grant, and execution is ordered. And if you don't do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of that prison term, you could be permitted to do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No.
You're remanded to custody. Thank you. All right, if we could have, okay, we'll go ahead and do Mr. Carter. All right, we have case number 24 CR 147, State of Ohio versus James Williams IV. And then there's also another case, 22 CR 189, same stuff. This is a sentencing hearing in case number 24 CR 147 being conducted by Zoom. Mr. Williams is appearing from the probation department. Ms. Hattner, I don't see you. Your video activated. There you go.
I'm just watching.
Yeah. Okay. I just want to see if you're awake. So.
Yeah.
All right. So Ms. Hattner is appearing by Zoom from her office, appearing from the prosecutor's office, is Prosecutor Collins, and Ms. Hattner, are you and your client both agree that this proceeding can be conducted by Zoom rather than in-person appearance in court?
Yes, we are.
You're all right with that, Mr. Williams?
Yes, Your Honor.
All right. Now, in case number 24 CR 147, I did refer the matter for a pre-sentence report. I have received that. Have each of the parties had an opportunity to review a summary?
I have, Your Honor.
All right. Anything from the state regarding sentencing?
Only what's contained within the plea agreement, Your Honor.
Ms. Hattner?
Thank you, Your Honor. We do ask that you follow the plea agreement as to community control. My client did talk with Ms. Sturgill about drug court, but it is my understanding that because he is now living in Montgomery County, that's outside the catchment area for drug court. But despite that, I do believe that he would still be a good candidate for community control.
All right, Mr. Williams, anything you would like to say?
Yes, Your Honor. I would just like the court to know that I accept full and complete responsibility for my actions and inactions and addictions. And by the grace of God, thank God, I am clean and sober today and continue to pass my drug tests and stuff for probation and the counseling center, obviously, that did the evaluation. But, have exceeded my required time frame with aftercare and recovery support groups with Goodwill Easter Seals, whom also helps with mental health stuff, employment, stuff of that nature. It's kind of just everything combined in one, which was great about it. But I'm successfully employed at full-time gainful employment now by the grace of God with KTH Industries, And I'll proudly say that I think I'm probably one of their best buggy operators, and they're one of the very best employers I've ever worked for, and I truly enjoy the job and was just hired in, not too long ago after having had to sacrifice a previous job as a maintenance person at McDonald's, where I told Mr. Balzer that I had to swallow my pride and accept that I'm going to now work my way up and work in fast food and not be against that, as I once was and said I'd never work in fast food. But you got to start somewhere and you got to work your way up, and I ended up having to sacrifice that job to ensure that my parents, whom I care for, my mom on a walker, dad on a cane, just got him a walker, and now he's got to start using it very soon because he's constantly falling down. I'm having to pick him up or find his cane. But so with that said, I just am very blessed with this job and being able to be there for my parents and my family. And I also have my beautiful, wonderful mother here, Frida Williams, with me today, and my Aunt Barbara Coulter of Hillsborough, Newmarket, and James Coulter, my uncle. And I just want the court to know that any other time prior to today, I would actually personally recommend a prison sentence for the James Williams I used to know. But today, I believe without a doubt that not only it's part of the plea agreement with the state and counseling center being in support of me, but also I believe Mr. Balzer as well, and I certainly would hope that he'll have an opportunity to state something to the court as well. But I get it, I got it, and the message is received. I've had some major spiritual awakenings and been through quite a bit. But thank God the best thing ever happened to me was meeting Mr. Drew Balzer, as much as I didn't want to meet him that day. And that was the day of this case when he had sent me give me an opportunity to go to the Genesis program. Best thing ever happened to me, inpatient, successfully completed it, have been back there time after time to do, I guess what you would call motivational speaking engagements, to share my experience, strength, and hope at their engagements and in their church services. I attend church every Sunday now, or for the most part every Sunday with my mom and dad. But blessed and grateful and thankful and just glad to be here and glad to be clean and sober and able to share this with you and be actually genuine and sincere about it. So I would just continue to ask the Lord to go with the recommendations and allow me to continue to live a successful life once and for all. Thank you, Ron. And thank you to Mr. Balzer and Mr. Benson and the court, everybody. They have been very supportive, encouraging, and motivating. And without them, without Mr. Balzer specifically, I wouldn't be where I'm at today. Thank you.
So my understanding, you've completed your aftercare.
Yes.
Are you still doing?
But I continue to just go. They let me come when I want to come.
Right.
And
okay, I just want to make
sure
that you've completed. I knew you said you were still doing things, and that's a good thing.
Yeah, it's pretty much AA and NA, the 12 steps. Right. That's the main thing at this point.
Okay, that's all I need to know. Thank you. All right, it's a judgment of the court that you be and are hereby sentenced to a term of 3 years of community control under the following conditions. You're to obey all laws, all jurisdictions, conduct yourself in a law-abiding manner at all times. You're to report when and as directed, and be truthful in all statements you make to the probation department. You must keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You must have a copy of a written pass with you if you are out of state. You're not permitted to enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. You may not purchase, possess, own, use, or have under control any firearm, ammunition, dangerous ordnance, or weapons of any other type. And as far as the firearms, ammunition, and dangerous ordnance, those, if you had those would be a violation of both felony and federal and state laws that would subject you to being prosecuted for a felony in either or both of those jurisdictions. You are not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant of any of those that may of controlled substance, drug abuse that may have effects similar to those. Nor may you possess or have or purchase an instrument, device, or thing that may be used to administer or prepare drugs to be administered, unless you have a lawful prescription for each of those items, both the substance as well as the device. And if you do, you must provide copies of those within 24 hours of receipt to your probation officer. You may not, or you must submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage or be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, is a member of a gang or any criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions. You're not permitted to marry or establish cohabitation in a common law type of relationship with another without written permission. You must report any contact with law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for any evaluation or assessment for further treatment, counseling, training, therapy, etc., you're to submit to that. If there's a recommendation that you undergo treatment, then you're to enroll in and successfully complete that program. You'll be required to pay the court costs and make payment arrangements with the clerk to do that. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your vehicles, residence, or any property or place that's under your control where you're found at any time. And any officer of the probation department will be required to sign a written acknowledgement and consent for that at the probation department. Now, in the event that it's alleged that you have failed to comply with these conditions, the probation department will file a written notice of that with the court and give you a copy. There will be a hearing if you, and you'll be entitled to have an attorney at that hearing. If the outcome of that hearing is that you failed to comply, then at that time the court could revoke your community control and sentence you to a term of incarceration between 6 and 12 months, fine you $2,500. And if that occurs because you were convicted in part or whole due to another felony conviction, and you received a prison term in that case, then the sentence in this case could be ordered to be served consecutively to that. If that prison term is to prison, if that term of incarceration, I should say, is a prison sentence, upon completion of that, the Adult Parole Authority does have the authority under the law to put you under what's called post-release control for a period of up to 2 years. If they do, you'll be supervised by the parole officer that is in charge of your area. And if during that period of time the parole authority determines you failed to comply, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control. Whichever is greater, if that occurs, that has to be served consecutively to the sentence in the new case. Now, that completes that case. Now we also have the allegation of violation of the case which Mr. Williams was on probation for in this court, and that is case number 22 CR 189. And in that case, Mr. Williams was placed on community control, also for aggravated possession, a 5th-degree felony of methamphetamine, and that was on December the 13th of 2023. Now, there was a notification filed by the probation department, I believe, on I have it marked here. Yeah, there it is. On March the 18th, alleging that because of your conviction in the 24-147 that I just sent you on, that that was a violation of your community control. Now, this would be the notification of that. Obviously, since I put him on community control, I'm not going to revoke him and send him to prison on this. But Ms. Hapner, you were aware of this. I think it's been discussed previously. And are you in agreement to go ahead and proceed with this now?
Yes.
All right. Do you have any problem with that, Mr. Williams?
No, Your Honor.
All Well, then it's the court's order that community control be extended in that case. And with an additional term that it's going to be extended to the end term in case number 24 CR 147. So that'll extend it by probably about a year or so. Mr. Williams, you had a year in when this came around, so it'll basically what it means is you'll have 2 sentences potentially facing you if you do commit or if you do have your community control revoked. But otherwise, all the conditions remain the same. All right. Anything further, counsel?
No, Your Honor.
All right. Then just see the probation there on your way out. Thank you.
Thank you, Your Honor. Thank you.
Okay. Case number 24 CR 167, State of Ohio versus Gregory M. Willey. Mr. Willey is appearing from the Justice Center. This is a sentencing hearing. His attorney is Sarah Barger, appearing by Zoom from her office, appearing from the prosecutor's office, Prosecutor Collins. Defendant entered plea of guilty to aggravated possession of methamphetamine. The matter was referred to the probation department for a pre-sentence report. He was also referred to the drug court, and I have received the pre-sentence report and also indication that he meets criteria for drug court. And have each of the attorneys received or had opportunity to look at a summary of the report?
They has, Your Honor.
All right.
Yes, Your Honor.
All right. Mrs. Collins, anything further from the state?
Your Honor, we would ask the court to place the defendant on community control and order him to successfully complete the drug court docket. We would note that this is a case that's eligible, a TCAP case. So based on that, despite his prior record, we are asking the court to follow the joint recommendation of the parties.
Ms. Barger?
Thank you, Your Honor. We would just request that you follow the joint recommendation. He has been assessed and has been deemed a candidate for drug court. Mr. Willey is willing to participate in the program, and he thinks that this is really going to help be an extra support for him when he gets out when he is finished serving his current prison sentence.
All right. Mr. Willey, anything you'd like to say?
No.
What's your release date on your sentence from Brown County? I think it's Brown County, is it?
Yes, sir. July 15th right now without my good days.
July 15th?
Without the good days, yeah, but it's going to be July 1st because I'm going to get my good days, so it's going to be July 1st. But right now it's July 15th.
Okay. Well, you know, you do have a real extensive record, Mr. Willey. This is a 5th-degree felony, and it appears that, you know, substance abuse is your primary problem, and you have indicated you would like to be in the drug court, which I think is a good decision for you. You understand that I'm not ordering you to go in the drug court, that it's strictly voluntary if you seek admission to that, and you have filled out an application, and is that what you want to do?
Yes, sir.
Okay. All right. Well, Mr. Willey, the court was going to give you this chance, so it is the order of the court that you be accepted into the drug court docket and that you be placed on community control. Now, your community control will be effective on your release date from prison, and so whatever date that is, you're to report by the end of business the day after. So if you get released in the afternoon, you know, they close at 4:30, so we don't expect you to be able to get there. We know you can't get there by the end of the business, but by the end of the next business day. If it's a Friday afternoon, you get released, it's a Monday morning you have to or Monday you have to report. If it's Wednesday, then you got to report by the end of business on Thursday.
I understand, sir.
Then your term will start at that time. Now, you're required to comply with all the conditions that are in the drug court docket program description. I know you signed a acknowledgement you received that. You do have a copy of that?
Sure.
All right. So you'll be required to comply with all those conditions. And there will be a treatment plan that will be formulated for you once you're released from prison and you report to probation. That'll be the topic to discuss the treatment program that you're going to need to follow. You're to obey all laws of all jurisdictions. Conduct yourself in law, body, manner at all times. Report when and as directed. Be truthful in all statements you make to the probation department. Keep them informed of residence, place, and employment at all times. You may not change either without written or without prior permission. Not permitted to leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of a correctional facility or communicate with anyone who's an inmate in those facilities without prior written permission. Now, with your record, I'm sure you're aware of this, but you're not permitted to purchase, possess, use, or have under your control any firearm, ammunition, or dangerous ordnance. To do so would be a violation of both federal and state law. They could expect you to be prosecuted in both jurisdictions. It's also a condition you not have any of those items or any other weapons of any type while under community control in this case. You may not purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD, oil, kratom, any variant or analog of a controlled substance, drug abuse that has effects that may be similar to those, nor may you have any instrument, device, or thing that may be used to administer drugs or prepare them for administration or use unless you have a lawful prescription. You must provide a copy of that within 24 hours of receipt to the probation department. You're not permitted to obtain a medical marijuana card. You must submit to drug testing when and as requested. That'll be a daily call-in thing that you'll have to call in, and then you'll have a window of time to report to be tested. If you're not permitted to purchase, possess, use, or have in your control any alcoholic beverage or be present in places where they're sold or being consumed, even if it's otherwise lawful. You're not permitted to associate with anyone who's a co-defendant in this case, or any other person who has a criminal record, a member of a gang or a criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, unless approved in writing by your supervising officer. That applies to any family members that may fall within that definition, unless you were living with them immediately prior to the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation or a common law marriage type relationship with another without written permission. You must report any charge of violating the law or any arrest, citation, conviction, or other charge relating to the violation of the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay your fees or costs can be reviewed. And if you're referred for treatment, for evaluation treatment, of treatment, therapy, counseling, programming, etc., by probation department, you'll submit to that, and if there's a recommendation for any type of programming, you're to enroll in and successfully complete that. Now, and you'll also pay the court costs to make payment arrangements to do that. Now, and finally, you'll be required to comply with your treatment plan that is recommended by your treatment team. Now, by being placed on community control rather than being sentenced to a term of incarceration, you are deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're found at any time by any officer of the probation department. You'll sign a written acknowledgement of that and consent with that with the probation department when you report. There will be no fine or driving suspension imposed. The court costs are also substantive ordered. If you don't pay those costs or make payments on them, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, and other assets you may have. And could also refer for collections, and if that occurred, you would pay a 30% fee on top of the cost for that collection fee. If that doesn't collect it, the court could permit you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you worked will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have failed to comply, they will file a written notice of that with the court. You'll get a copy. There will be a hearing at which you'll be entitled to have an attorney represent you. If the outcome of that hearing is you have failed to comply, then at that time the court could terminate you from the drug court, revoke your community control, and sentence you to a term of incarceration between 6 to 12 months and a fine of $2,500. If that term of incarceration is to a prison, upon completion of that prison term, the adult parole authority could put you under post-release control for a period of up to 2 years of the terms they set. And if during that period of time they found that you failed to comply, they could return you to prison as a sanction to make you serve an additional period of up to half of the prison term I've imposed at that time for one or more violations. But if you committed a felony offense, Then, in addition, whatever sentence the judge in that new case can impose upon you, that judge could also sentence you for committing that offense under post-release control in this case for an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
Okay. So when you get out of prison, Mr. Willie, you need to get yourself to probation by the end of business the next day. All right, thank you.
Thank you.
Kirk. All right, this is case number 25 CR 004, Stable versus Kirk S. Burcham. Are you Kirk S. Burcham, appearing there from the jail?
Yes, sir.
All right, this is a sentencing hearing. Mr. Burcham has entered plea of guilty to aggravated possession of methamphetamine, a fifth-degree felony. His attorney is Sarah Barber, appearing from her office. Appearing on behalf of the state is prosecuting attorney Collins. The court referred this matter to the probation department for a pre-sentence report, which I have received. Also, the case was referred to the drug court docket, and I did receive a statement from Mr. Sturgill, the drug court coordinator, that he is does meet the criteria for admission into the drug court docket. I do note there's a holder out of Chillicothe Municipal Court for theft, and there is a bed available for him at moving forward on April the 7th. All right. Ms. Barber, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person hearing?
Yes, Your Honor.
You all right with that, Mr. Burcham?
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
We would ask the court to follow the joint recommendation, place the defendant on community control and order him to successfully complete the drug court docket.
Ms. Barger?
We would just request that you follow the joint recommendation at this time. The defendant does have an extensive criminal history, as the court pointed out. However, he has maintained this entire time how he's ready to have a change in his life, and he wants to make that change, and he fully believes that drug court is going to be that for him, that extra support and that extra kick that he needs to get over the hump and stay sober.
Mr. Burcham, anything you'd like to say? Is there anything you would like to say?
I would just like to thank you for this opportunity, sir.
The charge in Chillicothe Municipal Court, is that a misdemeanor?
Yes, sir.
Okay. And you still have that case pending?
Yes, sir.
All right. And Ms. Sturgill, when you talked with them, did they indicate whether they might be disposed of going along with releasing him to treatment on the 7th, or would they want him back?
Sir, I reached out to talk to his defense attorney, and he hasn't been assigned one just because it's been a failure to appear, but he was incarcerated in our jail and picked up like 3 failure to appears. I have talked to them in the past about previous cases, so I feel confident that they will. If they can't manage it by the 7th, I'll just push the bed date out a few days.
Okay. All right. Well, Mr. Burcham, you do have a very extensive criminal history. I don't know, forgot how many convictions. Looks like 2 felony convictions, and then a whole slew of misdemeanors for a whole bunch of different things. Some traffic, some drugs, some assault, domestic violence. So you have an extensive history. It does appear that substance use disorder or substance abuse is the common denominator. And so, despite that record, what I would say is that drug court is designed for people with serious needs, including repeat offenders. It's not designed for a first offender. But it's also a voluntary program. You have to want to be in it. I don't order people to go in it because if I do, this is a waste of time. You have to be committed to making this change. Difference between drug court and regular community control is community control, basically probation department is trying to make sure you can meet minimum standards to stay out of prison. With drug court, the idea is to get you sober, help you rebuild your life, learn how to stay sober, so that you can become a productive member of society. Because if you do that, then it's unlikely you're going to return to prison. And so it is much more intensive. It's more of a commitment. It's more difficult, but it also has a bigger reward if you're successful. And so I know you filled out an application and indicated you wanted to be in the drug court. Is that what you want to do? I didn't hear you.
Absolutely, Your Honor. I am ready to change. I'm willing.
All right, thank you. Then court will order that the case be placed in the drug court docket, and the defendant is placed on community control under these conditions. I know you did receive a copy of the program description, correct?
Yes.
All right. Well, in the short version is that you're required to comply with all those conditions as a condition of your community control. I am going to highlight some of them, but the ones I don't mention are still applicable as set forth in your handbook. You're going to be under community control for a period of 3 years under the drug court docket conditions. You'll be required to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department, keep them informed of your residence, place, and employment at all times, and not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You shall not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. You may not purchase, possess, own, use, or have under control any firearm, ammunition, or dangerous ordnance. And because of this conviction and others, if you do that, that's a violation of both federal and state laws, subject to being prosecuted for felony. It's also a condition you not have any of those or any other weapons of any type while on community control in this case. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of a controlled substance or drug abuse that's effects similar to those, nor may have an instrument, device, or thing. May be used to administer drugs, prepare them for administration. Unless you have a lawful prescription, you must provide a copy of that within 24 hours of receipt. You may not obtain a medical marijuana card. You must submit to drug testing when and as requested by the probation department, the treatment team, or the program prescription. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverages. You may not associate with anyone as a co-defendant in this case or any other person has a criminal record as a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to violate these conditions unless that's approved in writing by a supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation or common law marriage type relationship with another without written permission. You must report any contact law enforcement or arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs to be reviewed. Fees, fines, or costs to be reviewed. If you're referred during the time you're on community control of the drug court for any evaluation or assessment for further programming of any type by either the probation department or your treatment team, you're to submit to that. If there's any recommendation of programming, you're to enroll in and successfully complete that. You'll be required to pay the court costs, make payment arrangements to do that with the clerk. And you must comply with the treatment team treatment plan recommended by your treatment team. Now, by being placed on community control rather than being sent to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property or place that's under your control where you're found at any time, any officer of probation department. There'll be no fine or suspension of your driving privileges imposed. You'll be required to pay the court cost as a subsequent order, and if you don't make payment arrangements, the clerk will be able to collect that through various means, including levying on bank accounts, wages, or other earnings that you may have. And if that could also include referral to a collection agency, which means you'd have to pay an additional 30% on top of the actual cost. And if that doesn't collect it, you could do community service in this county and be given credit for each hour you work, and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event it's alleged that you have failed to comply these conditions, probation will file a written notice out with the court. There will be a hearing. You will get a copy of it. There will be a hearing which you'll be entitled to have an attorney. The outcome of that hearing is that you have failed to comply. Then the court can terminate you from the drug court document, revoke your community control, and sentence you to a prison term of between 6 to 12 months, and fine you $2,500. If that occurs because you were convicted of another felony while in community control and received a sentence of incarceration for that offense, the sentence imposed in this case could be ordered to be served consecutively to that in the new case. If that occurs and you're sentenced to prison, upon completion of that prison term, the adult parole authority may put you under post-release control supervision for up to 2 years. If they do, you'll be supervised on the terms they set. If during that period of time they determine that you failed to comply, they can return you to prison, make you serve as a sanction an additional period of up to 1/2 of the term of incarceration for one or more violations. However, if you are convicted of a new felony offense while under post-release control, then in addition, whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control. Whichever is greater, and if that occurs, that must be served consecutively to the sentence in the new case. All right. Now, it's also ordered that you're going to have a bed available for you, but you're going to have to stay in jail until we see what goes on with Chillicothe. And so if they don't lift, if they take you down there and then they release you, report back to probation. Your bed date right now is April the 7th. But if you are in jail longer than that,
As a county court sentence till the 10th.
okay. I just have a note from bailiff that according to sheriff, you have a sentence out of county court that goes until April the 10th. Are you aware of that, Ms. Sturgill?
I did look at that. I thought his time was suspended. I saw I have reporting probation and community service on it. I did not know the jail time was there, but I can...
Okay. Well, you'll have to check with them. So what it means is, Mr. Hill, you may have to stay in jail on these holders, not on this case, until those cases are cleared. But if you get released and somebody from probation is not there to pick you up, report back to the probation department because they'll need to get you a bed available, and hopefully it'll be pretty quickly. Okay? All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. Okay. Jared Hill. All right. Are you Jared R. Hill, appearing there from the jail?
Yes, sir.
All right. This is case number 25CR27, State of Ohio versus Jared R. Hill. Mr. Hill's appearing from the Justice Center by video, Zoom. His attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. This is a matter for sentencing. Defendant entered a plea of guilty to trafficking in marijuana. Now, Ms. Barger, are you and your client both in agreement that this matter can be conducted by Zoom rather than an in-person appearance in the courtroom?
Yes, Your Honor.
And you're all right with that, Mr. Hill?
Yes, Your Honor.
All right. So the defendant entered a plea of guilty to trafficking in marijuana. Court ordered a pre-sentence report, which I have received and reviewed. Have each of the parties received a summary?
State has, Your Honor.
Yes, Your Honor.
All right. I also note that there was a referral to drug court. Sturgill, the drug court coordinator, has indicated that he has had no drug use other than marijuana since 2022. Has completed the Alva's house successfully in October of 24, and therefore it did not appear at this time that he would meet the criteria for drug court. All right. Anything from the state regarding sentencing?
We would ask the court to place the defendant on community control at this time in order that he pay restitution to the task force.
All right. Ms. Barger?
We would ask that you place Mr. Hill on community control. I will say on Mr. Hill's behalf, this is a completely different Jared from the first time that I met him. He actually appears clean and sober. He is cooperative. He fully accepted his responsibility in his actions in this case. First time I met him, it wasn't an argument like it had been in the past. He wanted to talk. He wanted to see what we could do to work out the case. He wanted to move forward. As soon as he found out he'd had drug court, he was all over it. He wanted to participate and get the additional support that drug court could provide. Unfortunately, him not being a candidate, he would still be equally as needing support while he's on community control. And if he needs extra help, it's my understanding that probation would be able to provide that for him. So we just ask that the court let him continue and go on community control at this time.
Is my understanding Mr. Hill serving a misdemeanor sentence out of municipal court? Is that correct?
I believe he is, Your Honor, and he is in yellow because he is a trustee in the jail.
Okay. And what's your outdate on that, Mr. Hill?
My misdemeanor time is completed, Your Honor. It completed the 26th of this month.
Okay. All right. Well, again, Mr. Hill, I mean, you've showed a lot of progress in your life, and I think that drug court probably could help you, but we do have some criteria we must follow, and so at this time, you don't meet those. But the court is going to go ahead and order that you be sentenced to a term of 3 years of community control under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed. Be truthful in all statements you make probation to the department. You must keep them informed of your residence or place of employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. If you do, you must have that pass with you. You're not permitted to enter upon the grounds of any correctional facility, nor may you communicate or attempt to communicate with anyone as inmate in any of those facilities without prior permission in writing. You're not permitted, because of your convictions, to purchase, possess, own, or use, or have under your control any firearm, ammunition, or dangerous ordnance, and to do so would be a violation of both federal and state law that subject you to being prosecuted in both jurisdictions for a felony. You're not allowed to have any of those or any other weapons of any type while on community control in this case. You're not permitted to purchase, possess, use, or have under control any controlled substance, drug abuse, CBD, oil creator, or any variant or analog of any controlled substance has effects similar to controlled substances or drugs abuse. Nor may you have any instrument, device, or thing that may be used to administer or prepare for use of drugs unless you have lawful prescription both for the substance as well as the device. And you must provide copies of those within 24 hours of receipt to the probation department. You're to submit to drug testing when and as requested. You may not purchase, possess, use, or have under control any alcoholic beverage or be present where they're sold or being consumed, even if it is otherwise lawful. You may not associate with anyone who is a co-defendant in this case, nor any other person that has a criminal record, a member of a gang or other criminal group, or any person who has in the past or could in the future, who employs you to commit a criminal offense and violates these conditions, unless that's approved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish cohabitation, a common law type relationship with another without written permission. You must report any contact with law enforcement, arrest, citation, or conviction or other charge of violating the law not later than the next business day after that occurs. You must provide your your supervising officer a financial information record so your ability to pay fees or costs can be reviewed. If you're referred by probation for an evaluation or assessment for any further treatment, therapy, counseling, training, or educational programming, you'll submit to that, and if there's a recommendation for programming, you're to enroll in and successfully complete that. You'll be required to pay the court cost of this action and make payment arrangements to do that. By being placed on community control, also you're ordered to make restitution in this amount of $50 to the Huntington County Task Force, and that's payable through the Victim Restitution Escrow Account. In the event that the probation department feels that you have failed to comply with these conditions, they'll file a written notice that with the court and give you a copy. There will be a hearing in which you'll be entitled to have an attorney. If the outcome of that hearing is that you failed to comply, then at that time you could be sentenced to a term of incarceration between 6 and 12 months, fined $2,500. If that sentence is to a prison facility, then upon completion of that term, the adult parole authority would have the right to put you under post-release control for a period of up to 2 years. If they do, you'd be supervised under those conditions, and if during that period of time they determine that you have failed to comply, they can return you to prison, make you serve an additional period of up to half of your prison term for one or more violations. But if you committed a felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. I also neglected to say that in the event your community control were to be revoked because you committed a new felony while under community control and you received a prison term in that, the prison term that would be imposed in this case could be or to be served consecutively to that in the new case. You're to report immediately upon your release from custody to the probation department. All right. Anything further, counsel?
No, Your Honor.
No, Your Honor.
All right. All right. Thank you. That's everybody in custody. All right. State versus Maryland. Case number 240123, State of Ohio versus Maryland K. Gross. Appearing on behalf of the state is Assistant Prosecuting Attorney King. Appearing on behalf of Defendant's Attorney Lindsay Arway. Are you Maryland K. Gross?
Yes, I am.
Mr. Gross entered pleas of guilty to two counts of assault, fourth-degree felonies. The court ordered a pre-sentence report. Have you received that, reviewed that? Have each of the attorneys received a summary?
The state has, Your Honor.
Yes, Your Honor.
Mr. King, had the victims or the representatives of the victims in these two offenses been notified of the time, place, and purpose of this hearing, the right to be present and be heard?
Yes, Your Honor, and the representative is present in the courtroom at this time.
All right. Anything for the state regarding sentencing?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation in this case. I would note that this defendant did accept responsibility for her role in this matter prior to the co-defendant, and she actually agreed to also testify against the co-defendant, which shortly thereafter resulted in the co-defendant entering a plea of guilty. As I indicated earlier, the representative is present in the courtroom this morning. Her name is Michelle Morris, and she would like to make a statement at this time if the court would permit.
All right. Go ahead, Ms. Morris.
to stand here?
Yeah, that'd be fine. Just state your name if you would, please.
Sure. Good morning. I'm Michelle Norris.
All right.
I don't need it. Firstly, Judge Cost, thank you for the opportunity today to come before you and present a statement on behalf of my grandsons. Byron and Gabriel Daly are 12-year-old autistic nonverbal twins. They attend an autism and social disorder school in Batavia, Ohio. It is where they can receive life skills and speech therapy, occupational therapy, all of those skills that they need. During the time that they've gone down there for about 5 years, Marilyn Gross was the driver of the school van. And that was about for 5 years. She took them to and from each day, to school each day, and home each day. She drove while Roy Hansford, the aide, was their aide for the entire time, again, that they were at CEC North. At some point in that time, without our knowledge, it became acceptable to punish or specifically hit our boys with a fly swatter while they were in transit and presumably buckled in seatbelts. Did the boys tell us? No, of course not. However, I did hear a recording, a voice recording of Roy training a new aide stating that it was okay to hit our two boys because they couldn't tell. And then laughter by both Roy and Marilyn. So you hit children strapped in and you think it's funny. Do we know 100% what was done? What happened? No. How long it occurred? Whom did this, or even why? No, we don't, and likely never will. There were no cameras on the school transportation, although nearly all vans and buses have them. And to even begin to trust one word from Marilyn would be quite ludicrous. As when questioned, she didn't feel they had done anything wrong. I'm here today representing these boys to say it was wrong. It was very wrong. The boys have had repercussions of this that are far-reaching and that we may never fully know the effects of. More makes sense now for us than it did before, like running before getting on the van, crying, screaming, wanting to leave school, and not wanting to leave school and get on the van. How can we hope these boys will ever trust again? My husband and I certainly do not. These are not people to be trusted. The boys did not deserve this, but they do deserve that Marilyn K. Gross admit her guilt, not say her actions weren't wrong, and not portraying herself as the least guilty. You see, she allowed the acts to go on, never speaking up, not defending disabled children, and while storing the fly swatter on her van. Marilyn, you should be ashamed of yourself and the detrimental role that you played. At this time, my husband and I want to thank the Highland County Prosecutor's Office, Vincent Antonor of the Highland County Sheriff's Department, Lisa of the Victims' Rights Program, and you, Judge, for ensuring these matters move forward timely and for, again, hearing the boys' story and allowing them a voice. Thank you.
Anything else, Mr. King?
No, Your Honor.
Sarway?
Just very briefly, Judge. As noted...
Stand and address the court, please.
Please, I apologize, Judge. As noted by the state, there is a joint recommendation for community control. We would ask that Your Honor order Ms. Gross be placed on community control. She did accept responsibility by entering a plea of guilty. While she was not the individual who was in fact actually using the fly swatter, she does acknowledge her role in this situation, and that is the reason that she did enter the plea of guilty to the offenses that were before the court for our plea. But again, that is not to diminish the role either that she played, which is again the reason that she did accept responsibility. Reviewing the pre-sentence investigation report, Your Honor, there's nothing extraordinary to note. That is not to say Ms. Gross's life is not extraordinary, but merely to indicate that she's 65 years old, has never had any prior criminal interaction with the exception of, I believe, 2 prior misdemeanor speeding tickets. She has been a resident lived at her residence with her husband, Clifford Gross, for quite some time. They have 2 sons. She is also the custodian of her minor grandson, grandson who was 11 years old when Ms. Gross first retained our office. I'm not sure whether or not he has had a birthday or not. She is no longer involved with the schools whatsoever, has no intention, of course, of being involved with them, though I know there, as part of the plea agreement, was a provision that any licensing that she did not have would be revoked. But again, this is a very unlikely situation for Ms. Gross to find herself in the future. She has been compliant with all of Your Honor's orders while on bond and under pretrial supervision, and we just appreciate the court's time and consideration here today.
All right, Mrs. Gross, anything you'd like to say?
You don't have to, but you have a right to.
The only thing I want to say is that...
Stand
oh, I'm sorry. The only thing I want to say, Your Honor, is that I'm very sorry that it happened, but I went several times to my supervisor and told him what was going on, and they didn't do anything about it or put any cameras on the van. So, you know. Other than that, no. That's all I got to say at this time. Thank you.
Well, looking at the summary, both when you spoke to the probation department as well as the summary of the statement you made to the investigating officer, there was no mention of that, Ms. Gross. And what concerns me here is that you haven't seemed to understand that what this was, well, fortunately, there was no serious physical harm involved. We have a couple of young men who are suffering from and living with autism, and they have very significant needs, and requires I think a greater measure of care for school employees when those persons are in their care. And as a bus driver, you were in charge of their care, and it seems to me that I don't know that you really accepted how serious this is, and what effect it could have on these young boys, and there were a couple of other students, I understand, but where Mr. Hansford said he didn't hit them because they could tell, whereas these boys couldn't. And so I have no evidence before me other than your statement that is now appearing in the record for the first time that you ever reported anything to anyone. And I can't imagine that if you reported that someone didn't take action. My understanding is from the report is the way this came to light is that there was a new aide being trained, and she saw Mr. Hansford hit those boys, and the next day brought an audio and then recorded a conversation with him and you, and that's how it came out. And your attitude on that conversation was very cavalier and frivolous. So, despite that, I'm going to follow the recommendation of the parties, and I'm going to, and it is ordered that you be placed on community control for a period of 3 years under these conditions. You obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department. You must keep them informed of your residence, place of employment at all times, may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate or attempt to communicate with anyone as an inmate in any of those facilities without prior written permission. You're not permitted to purchase, possess, own, use, or have under your control any firearm, ammunition, dangerous ordnance, or weapons of any other type while you're on community control. You may not purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, creative, or any variant or analog of any controlled substance that has effects similar to controlled substances or drugs of abuse, nor may you have any instrument, device, or thing that may be used to administer drugs or prepare them for administration, except those for which you have a lawful prescription, and you must provide copies of those within 24 hours of their receipt to the probation department. You're to submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any type of alcoholic beverage, nor may be present in places where they're sold or being consumed, even if it's otherwise lawful. You must report any contact with law enforcement and arrest, citation, conviction, other charge violating the law not later than the next business day after that occurs. You'll provide your supervising officer a financial information record so your ability to pay any fines, fees, or costs can be reviewed. If you're referred for an evaluation or assessment for any kind of programming by probation, you'll submit to that, and if any programming is recommended, you'll enroll in and successfully complete that. Pay the court costs and make payment arrangements to do that. Now, while I'm giving you community control, I think it's important for accountability to carry some punishment in this case, and particularly in view of the comment you just made here. So it is the order of the court that as a condition you serve 20 days in Highland County Jail. I was going to make it 10, but after the comment you made, which I think is false, I decided that a little more accountability is going to be required, so it's going to be 20 days. And I'm going to give you, I'm going to order that you report to the Sheriff's Department this Friday at 4 p.m. to serve that sentence. And I think that's important not just for punishment of what your acts are and your attitude, but also to send a message to other bus people that might think that it's all right to abuse children when they're in their care and they think they can get by with it, which is what was the case here. Now, by being placed on community control rather than being sentenced to jail, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control, or where you're found at any time by any officer of the probation department. You'll sign a written acknowledgement and consent of that with the probation department. Of course, also ordering that you pay a fine of $500 on each count to be paid in full by April 1st of 2026. Now, in the event you fail to pay the court costs, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. That can also include a referral to a collection agency, and the collection agency would be entitled to collect an additional 30% above the cost if that occurred. If that did not collect it, then you could be permitted to do community service in this county and be given credit for in an hourly rate set by the court for each hour you work. Each hour you work will reduce your judgment by that amount until paid full. Now, in the event that the probation department feels that you have not complied with the conditions set forth in this order, they will file a written notice that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of that hearing is that you failed to comply, then at that time, the court could revoke your community control and could sentence you to a term of between 6 and 36 months prison and a fine of $5,000. And in the event that that occurred, upon completion of that prison term, the adult parole authority would have the right to, at their option, to place you under post-release control for a period of up to 2 years. And if they did, you'd be supervised on the terms they set. And if they determined that you'd failed to comply, then they could return you to prison as a sanction to make you serve an additional period up to 9 months for a single violation, up to 1/2 of whatever the prison term was for all violations. However, if you committed a felony, then in addition, whatever sentence a judge in a new case to impose upon you, that judge could also sentence you to an additional period of 1 year or whatever time is left on that post-release control, whichever is greater, for committing that offense while on post-release control in this case. And if that occurred, that sentence would have to be served consecutively to the sentence in the new case. All right. Is there anything further from counsel?
No, Your Honor.
Not from defense, Your Honor.
All right. That completes the case. You're released from pre-sentence supervision or pre-trial supervision and your house arrest. But you will need to make arrangements, or you will be required to report. And Dale's going to give you a assignment notice here for the report to the jail this Friday by 4 p.m. to serve your 20 days. All right. Thank you.
Thank you, Judge.
Case number 21 CR 96, State of Ohio versus Jeremy M. Estes. Present for the State's Assistant Prosecuting Attorney King. Present on behalf of the defendant is, are you Nicholas, is it Graham?
Graham. Nobody ever gets it right, though, Judge.
And are you Jeremy M. Estes?
I am.
All right. All right, this is a motion to seal the record in this case. That was filed on, sticking over that, February the 6th. Defendant was charged with gross sexual imposition back in June of 2021. There was a jury trial on August the 10th, 2021, and at that time the jury found the defendant not guilty. And so the motion was set for hearing today. And is the State offering any objection to the motion?
No, Your Honor. The State has no objection.
All right. All right. Well, then the court will grant the order to seal, and you paid the $50 filing fee. All right.
I assume, yeah, when we filed it, I don't know if they would have taken it without that in that clause.
Right. Yeah, but it's been paid.
Oh, okay.
Yeah. Sometimes people that are pro se, and this wasn't, but they'll file, so that's why I'll ask. All right. So, Mr. Estes, the court will prepare the order, file it possibly today, if not by tomorrow, and that order will go out to all of the law enforcement and public agencies that have any record of this. Usually takes about 30 days for that to happen. Now, you're going to get a copy of this, and you should keep that. In fact, you should make a couple extra copies and keep them in different places, and don't give up your original one that's file stamped. Make copies of it if somebody wants. And the reason I say that is that this does not seal the records in hands of third parties or non-governmental agencies. So if there was something in the paper, if there's something in a background check or insurance check, it may still be there if you go to another place and they use the same source, and so they may say, well, according to this, you have this felony charge on your record, even though you're not guilty, and so that's why you need to keep your copies to show them so that they can understand that your record is now sealed. And the reason I also say that is that sometimes, we don't do it in this court, but well, at least I don't think we do. I haven't heard it happening. Is that? But I was in a case in another court in another county where I got a recall from the attorney that said I need to file a motion to reopen the case. My clients lost their copies, and the clerk won't even admit that the case is there, so they can't get a copy. So I had to sign an order to allow the case to be reopened for the purpose of getting copies. So that's why I say make numerous copies, keep them in different places so you don't lose them. Okay, anything further, counsel?
No, thank you.
All right, thank you. All right, so we're going to do these arraignments. right, are you Betty L. Groves appearing there from the jail?
Yes. Yes, sir.
All right, this is case number 25 CR 60, State of Ohio versus Betty L. Grove. The defendant was indicted yesterday on a charge of arson and criminal damage. The state is represented by Assistant Prosecuting Attorney Adam King, and Mr. King, as the alleged victim of the offense or offense, has been notified of the time, place, and purpose of this hearing.
Yes, Your Honor, we did reach out to them this morning and attempt to make contact. There was no answer. However, we left a voicemail and advised them of the arraignment.
All right. All right. Now, Ms. Grove has filled out a financial disclosure form and indicated she's on SSI, so the court finds that she is entitled to appointed counsel, and I appointed Attorney Dennis Kirk of Hillsborough, Ohio, to represent her, and Mr. Kirk is present in the courtroom at the court's request. And so, Mr. Kirk, have you had an opportunity to review the indictment yet?
Not yet. I'm aware of the charges and just some basic facts, but I have not reviewed the indictment.
All right. Do you wish to have the indictment read?
We will waive reading of the indictment and enter a plea of not guilty.
All right.
John said something.
It's downstairs for them to file as soon as she's arraigned.
All right. Now, regarding the matter of bond, Mr. King, the state wish to be heard. Oh, Mr. Collins has also joined Mr. King. Prosecutor.
Your Honor, the state is requesting a $10,000 bond in this case. I believe that's the bond that's been in place since the bind-over from county court, and the state also intends to file a motion to have this defendant's competency evaluated forthwith.
All right, Mr. Kirk, anything you'd like to say?
At this point in time, I don't know much about the case, but I am advised that perhaps the defendant may have some competency issues. So if I become aware of more information that might affect the bond, I'll file a motion at that point in time.
All right, Ms. Grove, the court is going to set your bond at $10,000 plus a service fee deposit of $171 and an OR bond, which is your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And if convicted, sentenced on that, no matter what happens in this case. If you do make that bond, you'll be under pretrial supervision of the probation department. You'll have to report to them at 117 East Main Street. You'll report to them as soon as you get out. You're required to report to them once a week for 4 weeks. And after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, employer. You're not to have any contact with the alleged victim or victims. If recommended by probation, you're going to be evaluated for substance abuse or any mental health issues. If any treatments indicated, you'll roll in and follow that during the period of this action. You'll also be under house arrest at your home, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend job or any kind of educational programming and church services. Other than that, you have to be there at all times. Now, court will set bond in this matter. I'm sorry, set trial date in this matter. I see the speedy trial date is 13th of June. I understand there may be requests for competency, and if that is filed, the court will certainly revisit the scheduling at that time. But for now, I'm going to set the first pretrial for April the 16th at 1 p.m. and a final pretrial for May the 21st at 1 p.m. and then the trial will be set for June the 12th at 8 a.m. All right. Anything further, counsel?
No, Your Honor.
Your Honor.
All right. Your attorney will be out to see you, Ms. Grove, to talk to you about the case, okay? I can't hear. I can't hear what she's saying. I don't know if your video is working. Probably better for her. She waved at me.
Okay.
Your Honor, I muted it. You didn't want to hear all that.
All right.
Who would you like next?
Curtis. All right, are you Curtis Walden appearing there from jail?
Yes, sir.
All right, this is case number 25 CR 53, State of Ohio versus Curtis W. Walden. Mr. Walden, you were indicted by the grand jury yesterday on 3 charges of unlawful conduct, sexual conduct, of minor third-degree felony. State's represented in the courtroom by Prosecutor Collins, Assistant Prosecutor King. These offenses allege in count 1, Mr. Walden, that on or about August 15th through 2024 through March 2nd of 2025 in this county, being 18 years of age or older, you engaged in sexual conduct with a person identified as V with a birth date of 8/4/2010 who was not your spouse, and you knew that person was 13 years of age or older, but less than 16 years, which would be 14, or reckless. And at that time, you were more than 10 or more years older than the V. And that's a violation of Section 290704 of the Ohio Revised Code. And then count 2 alleges the same thing, second count, same offense, and count 3 is also the same offense. And so each of those offenses carry a possible prison term of between 12 and 60 months in prison, a fine of $10,000, and if convicted, a requirement to be designated as a Tier 2 sex offender subject to registration requirements. Now, you're entitled to have counsel in this matter, Mr. Walden. You do not have the money to hire one. The court will appoint one for you. And I see that you did fill out a financial disclosure form. Everything on this form correct?
Yes, sir.
All right. All right, then the court will find that you are entitled to appointed counsel. The court will appoint Attorney Danielle Witt of Hillsborough, Ohio, to represent you. And in the absence of counsel, the court will enter a not guilty plea on your behalf. I forgot to mention to the state, have the alleged victim or a representative been notified of the time, place, and purpose of this hearing, the right to be heard?
Yes, Your Honor, and the representative is present in the courtroom at this time.
All right. All right, we'll set up bail review hearing. What we have for tomorrow. Go ahead and set the first pretrial in this case for April the 16th at 1 p.m. What do we have tomorrow afternoon? Is Danielle going to be here?
I don't have her now.
Okay. Let's see. Yeah, I've got to be gone every afternoon. So
You have an 8:30 Zoom already.
well, I've got to give it a little more time than that, so I'll set it at 11 o'clock. Okay.
You do have resentencing on that guy.
Yeah, I know.
Okay, 11.
Yeah. All right. Bond review hearing will be tomorrow, the 3rd of April at 11:15 a.m. First pretrial, they indicated it's 4:16. Final pretrial will be May the 7th, and trial date will be set for May the 23rd. The pretrial on May the 7th will also be at 1 p.m. Bond will be set in the amount of $30,000 plus OR, which is your promise to appear, Mr. Walden. If you fail to appear, you could be prosecuted for an additional felony and a convicted sentence, no matter what happens in this case. You'll be required to pay a deposit of $171 prior to release to cover certain statutory required fees. You'll be under pretrial supervision of the probation department at 117 East Main Street. If you do make bond, you report to them immediately upon your release. Report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, they may order. Provide phone numbers for home, cell, employer, not to have any contact with the alleged victim or any family member of any kind, directly or indirectly. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment is indicated, you enroll in and follow that during the pendency of this action. And you'll also be under house arrest at your residence at, is that the residence of the alleged victim? 1000 South 5th Street.
Yes.
All right, so then the residence will be determined, could not be there. Wherever you end up residing, you'll be under house arrest at that location, unless you're going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer, in this or any other case, or attend any kind of job training, educational programming, or church services. Other than that, you have to be there at all times. All right, we'll notify your attorney of your appointment, and we'll have your bond review tomorrow afternoon, or tomorrow morning, I should say. All right, thank you. All right, this is case number 25 CR 56, State of Ohio versus Skylar D. South. Are you Skylar D. South appearing there from the jail?
Yes, sir.
All right, Mr. South, you were indicted by the grand jury yesterday on a charge of aggravated possession of methamphetamine, a 5th-degree felony, and that alleges that on or about May 11 of this year, in this county, you knowingly obtained, possessed, or used methamphetamine, a Schedule II controlled substance. If convicted, that carries a possible term of incarceration of 6 to 12 months and a fine of $2,500 and a possible license suspension of 6 months to 5 years. Now, you are entitled to have an attorney to represent you in this matter, and if you don't have the money to hire one, the court will appoint one for you. And I see you have filled out a financial disclosure form. Is everything on this case or on this form correct?
Yes.
All right. Court then will find your title, appointed counsel, appoint attorney Danielle Witt to represent you, and in the absence of counsel, I'll enter a not guilty plea on your behalf. The court will set a bail review hearing for tomorrow, April the 3rd at 11:15 a.m. by Zoom. Your first pretrial will be April the 16th at 1 p.m. Final pretrial will be May 7th at 1 p.m. And trial date will be set for June the 9th at 8 a.m. Bond will be set in the amount of $2,500 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for additional felony. And if convicted, sentenced on that no matter what happens in this case. You'll be under pretrial supervision if you do, or you also be required to pay a deposit of $171 prior to release. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll be required to report to them immediately upon release, then report once a week for 4 weeks, and after that, as they determine, under random drug testing they may order, provide funding for a home self-employer. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. And if treatment's indicated, you'll enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 6489. Is that West Welcome Road?
Yes, sir.
All right. West Welcome Road in Hillsborough. Meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney and probation officer in this or any other case. You can also attend any kind of educational programming, job training, etc. So we'll notify your attorney of her appointment. We'll have your bail review hearing tomorrow. All right, thank you. All right, then Mr. Matthew Jones. All right, are you Matthew O. Jones?
Yes, sir.
All right, this is case number 25 CR 58, State of Ohio versus Matthew O. Jones. Mr. Jones, you were indicted by the grand jury yesterday on 3 charges of rape and 1 count of gross sexual imposition. So this is your arraignment. The prosecutor and Collins and her assistant, Mr. King, are present in the courtroom, and has the alleged victim or victims or representative been notified of the time, place, and purpose of this hearing, the right to be heard?
They have been, Your Honor.
All right, Mr. Jones, the first count alleges that on or about the period of January 4, 2024 through January 4, 2025 in Highland County, Ohio, you engaged in sexual conduct with a date of birth 1/4/2018, who was not your spouse, and was less than 13 years of age, to at 6 years of age and under 10 years of age, whether or not you knew the age of the. So that's a charge of rape, which in this instance would carry a potential sentence of life without parole. Count 2 basically alleges the same offense, also against V, so it would be the same charge, the same penalty. Count 3 alleges the same offense as well during the same period of time. Same alleged victim, same offense, same penalty. So 3 counts of rape, first-degree felonies with possible life without parole sentences. Then the 4th count is gross sexual imposition. That alleges that on or about January 4, 2024 through January 4, 2025 in this county, she had sexual contact with V, who was not your spouse, and was date of birth 1/4/18 and was less than 13 years of age to at 6 years of age, whether or not you knew that age. And so that would be in violation of Section 290705A4, and is a 3rd-degree felony, which carries a possible prison term between 12 and 60 months and a fine of $10,000. Also, with regard to count 1, that requires a tier one designation as a sex offender, subjecting you to lifetime reporting on the sex registry. Now, you are entitled to have an attorney, and if you do not have the right or the money to hire one, the court will appoint one for you. So you have filled out a financial statement. Is everything on this statement correct?
Yes, sir.
All right. All right, the court then will find that you are entitled to appointed counsel. I'm going to appoint co-counsel for you in this case, Catherine Hapner and Sarah Barger, both of Hillsborough, to represent you in this matter. In the absence of counsel, I'll enter a not guilty plea on your behalf. We'll set a bail review hearing for tomorrow morning, April the 3rd at 11:15 a.m. That'll be a Zoom hearing. First pretrial will be April the 16th at 1 p.m. I don't know. Did I ask if the victim or representative had been notified?
You asked, and she
Okay.
has been.
All right, thank you. Been a long morning. Final pretrial will be May the 7th, also at 1 p.m. And the trial date will be set for June the 9th at 8 a.m. All right. And let's see, the bond recommendation in this case is what, $250?
It is, Your Honor.
All right, looks like the defendant has previous felony convictions, including sex offense registration requirements, so the court will set that bond at $250,000 plus your own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll also be required to pay a deposit of $171 in addition to the $250,000 bond that will cover certain statutorily required fees. You'll be under pretrial supervision of the probation department on 117 East Main Street, and you'll report to them immediately upon your release if you're able to make bond, and then once a week for 4 weeks after that as they determine. You'll go random drug testing in my order, provide phone numbers for a home cell employee, have no contact with the alleged victim or any family member. If recommended by probation, you'll be evaluated for substance abuse and mental health issues and any treatments indicated. Enroll in and follow that during the period of this action, and you'll be under house arrest, meaning you have to be at your residence at all times unless you're working. Going to and from work, medical appointments, court proceedings, in this or any other case, appointments with an attorney or probation officer in this and or that case, and also attend any kind of educational programming, classes, job training, etc., and also church services. Other than that, you have to be there at all times. If you fail to comply, that bond can be revoked, and the court could have you held till further order of the court. All right. We'll notify your attorneys of the appointment and bail review hearing tomorrow morning. Thank you. All right, this is case number 24 CR 83, State of Ohio versus Sonia R. Smith. Ms. Smith is appearing by video from the jail. Her attorney is Danielle Witt, appearing on Zoom from her phone, looks like. And on behalf of the state, Prosecutor Collins is appearing from her office. The defendant was convicted of aggravated possession of methamphetamine, a fifth-degree felony, and was placed on community control on September 26th. There was a notice of violation filed on March the 21st, alleging that Ms. Smith had failed to comply with Rule 19, that she successfully complete the STAR and aftercare program, and it alleges on March 20th, probation was notified that she had signed an unsuccessful discharge form and requested to leave the program. The court notified Ms. Smith of this alleged violation on the 24th, it looks like, and set the matter for hearing today, appointed Ms. Witt to represent the defendant. Ms. Witt, have you had an opportunity to review the matter with your client?
Yes, I have.
I should say, first of all, are you and your client both in agreement that we conduct this hearing by Zoom rather than in person? Okay.
Yes, we are.
Are you all right with that, Ms. Smith?
Yes, Your Honor.
All right. If you need to speak with your attorney or ask for any questions during the hearing, since you're not seated next to her in the courtroom, you tell me and I'll put the two of you in what's called a breakout room, and it'll be just you and her on the screen. No one else will be able to see you or hear you, and the deputy will step out of the room while that is taking place. Okay?
Thank you.
All right. All right. Now, Ms. Witt, does your client wish to have a hearing, or will there be an admission?
She does plan to admit, Your Honor.
All right. So, Ms. Smith, you understand the charge against you?
Yes, Your Honor.
All right. And under the law, you do have a right to have a hearing on this matter, in which the state would be required to produce evidence that proves to the court that you have failed to comply with those conditions. You have a right to have your attorney cross-examine any witnesses that the state presents. You also have the right to offer testimony and witnesses on your own behalf, although you're not required to do so. In the event that it's shown, either after hearing with evidence or by your own admission, that you have failed to comply with these conditions, I can do one of three things. I can continue your community control under the same conditions that were previously ordered. I can continue it with additional conditions I think are appropriate. Or the third and the most serious is that I could revoke and terminate your community control and then sentence you to a period of incarceration between 6 and 12 months and fine you $2,500. Now, do you understand that?
Yes, Your Honor.
All right. Has anyone promised you anything or threatened you in any way to get you to admit to these this alleged violation?
Yes, sir.
All right. Then do you admit the allegation filed against you that I just read to you on March 21st that alleges that you violated Rule 19?
Yes, Your Honor.
All right. Anything from the state regarding disposition?
Thank you, Your Honor. We have spoken with probation. At this time, we are requesting that the community control in this case be revoked and that Ms. Smith be ordered to serve a term of incarceration in the county jail. We would note that she has a prior prison sentence. During the time that she was on pretrial supervision in this case, she was not compliant with probation. She failed to appear at a sentencing hearing in this case when it was pending, and she's not been compliant with probation since she's been placed on it. So based on that, there is no indication that she is going to be compliant. She has 164 days of credit from the STAR program. We would just ask the court to order her to a term of incarceration at county jail and give her credit for what she has. Thank you.
Ms. Witt? Ms. Witt, do you have anything on behalf of your client?
Yes, Your Honor. In speaking with Ms. Smith, she does wish to continue into treatment and would like to be an inpatient while she has As Ms. Collins stated, spent a significant amount of time at STAR. She did find treatment very helpful for her and wanted to continue in that journey. So we just asked for her to continue in treatment and on community control.
All right, Ms. Smith, anything you'd like to say?
Yeah, Your Honor, I want to, first of all, thank you for sending me to STAR. Even though I didn't graduate, I completed STAR to the best of my ability. I completed all my classes. I joined the vocational called Rise Up. I got a 4.0 grade average in that with 3 certifications in customer service and warehouse logistics and customer service. I was fundamentalist, and I plan on using that to the best of my ability when I get out. The program taught me a lot about myself. I'm proud of who I became now. I plan on, no matter what the outcome today is, planning on staying in treatment when I'm released or stay here or however it may go. And I want to thank you again for giving me the opportunity to go to STAR, because I did learn a lot about myself and it's changed my life tremendously.
Well, if you liked it so well and it was so effective, why did you leave?
They told me I timed out, that I couldn't be there over 180 days. And with the last ticket I got, that I would have been phase dropped and wouldn't have been able to complete anyway.
Well, Mr. Arjima, it's my understanding that she actually signed out, wanted to be discharged. Is that correct?
That is what I was told, yes, Your Honor.
All right.
Yeah, my behavior specialist told me that I wouldn't have time to complete. That it would be the best of my knowledge to go ahead and sign myself out and get back here. So I just went with what she had spoke with me about my last major, and I wanted nothing else but to complete that program. But the day before I was supposed to get my back string, and we've been my final 5 days, is the day that we had a basketball tournament, and a girl tried to start trouble with me, and I went and sat down by my case manager. We both got in trouble.
Well, looking at your history, every consideration was given to you during this case. You didn't appear. On 2 occasions, you had a bed available at TCC, and then again at TRC, and you didn't show up or report for those for either occasion. So we decided to send you to STAR, and then put you into probably transitional control after that with continuing treatment. But you didn't complete the STAR program. And the court has a requirement that if you're going to go to STAR, you're going to complete it. If you don't, then you're going to do time. And that's particularly evident in this case that there's no sense in continuing you on community control, because you're not going to do anything other than weave another line of BS that you just gave me, because you just don't want to comply. So I'm going to grant that wish. You don't have to go to treatment anymore. Once you get done with your term of incarceration, you're free to go out and kill yourself by using drugs, because that's what's going to happen. And so it's the order of the court that your community control be revoked, that you have shown that you're not amenable to community control, and it is ordered that you be sentenced to the Highland County Jail for a period of 10 months, and that sentence will be credited with 164 days that you spent in STAR and an additional 35 days that you spent in the sheriff's custody during dependency of this case, for a total of 199 days. You're also ordered to pay the court cost, in which judgment granting execution is ordered. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, they can also do a collections agency referral, and then the collection agency was entitled to collect an additional 30% over above what you already owe for the court costs. Or if you're not able to do any of that, the court could permit you to do community service in this county and would give you credit for each hour you worked, and an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. All right. Is there anything further from counsel?
No, Your Honor. No, Your Honor.
All right, thank you. You're remanded back to custody then. Is that the only one in jail? Case number 24 CR 87, State of Ohio versus Ashley Thomas. Present on behalf of the state is Assistant Prosecutor King. Present on behalf of the defendant is Attorney Danielle Witt. Ms. Thomas is not present. The defendant entered a plea of guilty on February 24th to a charge of aggravated possession of methamphetamine, a fifth-degree felony. And the matter was set for a sentencing hearing today. A pre-sentence report was ordered. I did receive that. I do have a fax from the probation department dated yesterday indicating she had failed to complete her SUD assessment. Mr. Appointment of reach on March 25. Failed to reschedule. Mr. Report date at probation on 25th. Called, said she had no ride. Rescheduled for March 28th. Missed a report date on that date. Officer Benson, has there been any other contact with her since yesterday?
I spoke to her this morning, reminded her to report when she was aware. She said she'd be in my office.
Okay, she's supposed to be here at 12:45, but I think that was actually the time set in the entry.
She did.
Yeah, it was. All right. Well, in the meantime, the report also said that she had not done her assessment. That was as of March the 25th, although I did get where this came from, but April the 1st, from the Addiction Services Council in Cincinnati. Apparently she had a holder in Brown County, but she's not in custody? No. All right. Have you heard from her, Ms. Witt?
I have not, Your Honor.
You have me in juvenile court, what, at 1?
No, I don't have any other hearings today.
Oh, okay. All right. Well, let's recess this for about 10 or 15 minutes, see if she shows up. And then if not, I'll store her cases for her. If she shows up, she'll stay in jail till we can get it rescheduled. All right. All right, this is case number 24 CR 177, State of Ohio versus Rodney McCarty. Present on behalf of the state is Assistant Prosecutor Adam King. Present on behalf of the defendant is Attorney Danielle Witt. And are you Rodney McCarty?
Yes, Your Honor.
All right, Mr. McCarty entered a plea of guilty to having a weapon under disability, a third-degree felony. The matter was referred to the probation department for a pre-sentence report, which I have received, and have each of the attorneys had an opportunity to review a summary.
State has, Your Honor.
Yes, Your Honor.
All right, anything from the state regarding sentencing?
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation and place the defendant on community control. There is a forfeiture of a firearm in this case, and that would be to the Greenfield Police Department. That's all. Thank you.
Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation and continue Mr. McCarty in treatment. It's my understanding he's been doing very well. He was telling me about some positive changes he's made in his life while being in treatment, including he just recently got baptized, I believe, over the weekend. So he's been doing a lot, spending his time usefully in treatment.
All right, Mr. McCarty, anything you would like to say?
No, Your Honor.
Now, are you still in residential treatment there at PARS?
Yes, sir.
All right, it is the judgment order of the court that you be sentenced to a term of 3 years of community control under the supervision of the Hynek's County Probation Department under these conditions. You obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department. Must keep them informed of your residence, place of employment at all times, may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may communicate or attempt to communicate with anyone who may make any of those facilities without prior written permission. You're not permitted, because of this conviction, to purchase, possess, own, use, or have under your control any firearm, ammunition, or dangerous ordnance. And you're not permitted to have that under the terms of this order or any other types of weapons. And because, as you know, it would also subject you to being prosecuted for an additional felony, which is what happened here, because of your disability. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of a controlled substance or drug of abuse that has effects similar to those. Nor may you have or possess an instrument, device, or thing that may be used to administer or use drugs or prepare them to be used unless you have a lawful prescription both for the device as well as any controlled substance, drug of abuse that you may have. You'll have to provide copies of that within 24 hours of receipt to the probation department. You're required to submit to drug testing when and as directed. You may not purchase, possess, use, or have under control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even as otherwise lawful. You're not to associate with any, I don't think it was a co-defendant, but with any person who has a criminal record as a member of a gang or other criminal group, or any person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions, unless approved in writing by your supervising officer. That would apply to any family members that may fall within that definition unless you were living with them immediately before the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation, a new relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, or conviction or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department for evaluation or assessment for any other kind of treatment, therapy, counseling, training, or educational program, you're to submit to that, and if there's a recommendation for programming, you must enroll in and successfully complete that. You must pay the court costs of this action and make payment arrangements with the clerk's office to do that. You'll be required to successfully complete your substance use disorder treatment and recommended aftercare at PARS, which is Pickaway Area Recovery Services, is abbreviated PARS in your order, and the substance use disorder treatment is SUD, is abbreviation for substance use disorder under Condition 19A of your entry. Now, by being placed under community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your vehicles, your residence, or any other property or place that's under your control where you're found at any time by any officer of the probation department. There will be no fine imposed in this case. The weapon in count 2 is ordered to be forfeited to the Greenfield Police Department. You're also ordered to pay the court costs as a substantive order, and if you fail to do that or make payments on your cost, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. Also, the clerk could refer it for collections to a collection agency, and if that occurs, they're entitled to charge an additional 30% above what is owed for the cost to do the collection. If you're unable to pay it in that manner, you can do community service in this county, and the court will give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount to pay the full. Now, in the event that the probation department feels that you have failed to comply with these conditions, they will file a written notice of that with the court. There will be a copy given to you. There will be a hearing, and you'll be entitled to have an attorney at that hearing. In the event that the result of the hearing is that you have failed to comply, then at that time the court could revoke your community control and sentence you to a term of incarceration of between 9 and 36 months in the increments provided by law, and fine you $10,000. And if your community control was terminated in part or in whole due to a new felony committed while under community control, and you received a prison term in that case, any prison term imposed in this case could be ordered to be served consecutively to that sentence. If that occurs, upon completion of your prison term, it is possible under the law that the adult parole authority would exercise the option to put you under what's called post-release control supervision for a period of up to 2 years. You'd be supervised under the terms they set by a parole officer, and if during that period of time they determine that you had failed to comply, then they would have the right to return you to prison as a sanction, make you serve an additional period of up to 9 months for a single violation. There is a cap or limit of half of your prison term for all violations. However, if you commit a new felony under post-release control, then in addition to whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right. Is there anything further, counsel?
There you go.
No, Your Honor.
All right. This completes your case. You're no longer under pretrial supervision or house arrest. You'll need to speak with the probation officer over here, make an appointment to arrange to have your case transferred to felony supervision.
Okay.
Thank you. All right. Emma Shoemaker. Case number 25 CR 30, State of Ohio versus Emma Shoemaker. Present on behalf of the state is Assistant Prosecutor King. Daniel Wynn, attorney on behalf of the defendant. And are you Emma M. Shoemaker?
Yes.
All right. Hold on here a minute. Misplaced your PSI file. All right, Ms. Shoemaker has entered a plea of guilty to trafficking of drugs, a 5th-degree felony. Thank you. The court ordered a pre-sentence report, and have each of the attorneys had the opportunity to review a summary?
The state has, Your Honor.
Yes, Your Honor.
All right. I note that there was a referral to drug court, and I do have a indication that she's now in residential treatment at the Recovery Council. Yes, at the Recovery Council. And letter from Ms. Sturgill indicating that she does meet the criteria for admission into the drug court docket. Mr. King, anything on behalf of sentencing?
Thank you, Your Honor. The state would ask that the court follow the joint recommendation and place the defendant on community control and also admit her to the drug court docket. There is restitution to the task force in the amount of $50. That's all. Thank you.
All right. Ms. Witt?
Yes, Your Honor. We also ask the court to follow the joint recommendation and for Ms. Shoemaker to be admitted into drug court. Even though she's only been in treatment just a few weeks, I believe since March 19th, I already do see a big difference in her, and she seems very excited about her sobriety.
Ms. Shoemaker, anything that you would like to say?
No, Your Honor.
Ms. Shoemaker, legally the court is not ordering anybody to go into the drug court docket. It is a voluntary program. Community control or probation is basically, the purpose of that is to impose certain conditions and hope that with the assistance of the probation department that you can comply with them sufficiently to avoid having to go to prison and serve a prison term. Now, the drug court docket is voluntary because it is a much more intensive and involved process. And, for instance, there's daily call-in if you're not in treatment, residential treatment. You could be required to call in every day and be required to come in to be tested several times a week and given a window to do that. There's a lot more services that are offered, but there's a lot more effort that's required. But the approach a drug court has is to try to not address the issue of keeping you out of prison, but rather addressing the factors that put you where you're at in this case. And that includes assistance through substance use disorder treatment, mental health treatment, because usually mental health is a component of the problem and it needs to be addressed. Help you build life skills, further your job training skills, and offer a number of different services and support. And so it is a minimum of 18 months in the program, and I think we've been averaging around 22 to 24 months for most people that are graduating. And so that's what's involved. But again, it's something you have to want. Now, I know you did fill out an application and you've been met with Ms. Sturgill and you've gone over the program description and you realize what's required in that program.
Yes.
Okay. And that's what you want to do?
Yes, Your Honor.
Okay. Well, then it is the order of the court that the defendant's application be granted and that she be admitted into the drug court docket. And it is further ordered then that she be placed on community control, Ms. Shoemaker, under the terms, for a period of 3 years, under the terms that's set forth in the program description and the attachments thereto that you've already seen. I'm going to go over some of those, but you're required to comply with all of the conditions in that program description. First of all, you're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You must report when and as directed. You must be truthful in all statements that you make to the probation department and your treatment team. You'll be required to keep the probation department informed of your residence and place of employment at all times. You may not change either of those without prior permission. You may not leave the state of Ohio at any time without prior written permission, and if you do, you have to have a pass with you when you're in that other state. You may not enter upon the grounds of any correctional facility or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. Now, because of your conviction, you're prohibited under both federal and state law from purchasing, possessing, owning, using, or having under your control any firearm, ammunition, or dangerous ordnance. If you were to do that, you could be prosecuted for an additional felony under both federal and state law and so be subject to incarceration. It's a condition you not have any of those items or any other weapons of any type in this case. You are not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of a controlled substance or a drug of abuse that has effects that would be similar to controlled substances or drugs of abuse. And you're not permitted to have any instrument, device, or thing that could be used to administer or use drugs or prepare them for administration or use unless you have a lawful prescription. And you have to have a lawful prescription both for the device or equipment as well as the substance. And you must provide copies of those within 24 hours of receipt to probation. You're not permitted to obtain a medical marijuana card while on drug court docket. You're not permitted to, you must submit, I should say, to drug testing when and as requested by the probation department or the treatment team. As I said, that will be fairly often, at least initially. And then it gets scaled down as the longer you go without being positive. Now, you are not permitted to purchase, possess, use, or have under your control any alcoholic beverage, nor may be present in places where they're sold or being consumed. So, even though that's not the issue in this case, alcohol is just another substitute for drugs, and so you're not permitted to do that because it interferes with your sobriety and you're being able to comply with the program. You're not permitted to associate with anyone who is a co-defendant in this case, if there was any, nor with any other person who has a criminal record or is a member of a gang or any other type of criminal group who has in the past or could in the future influence you to commit a violation of these conditions or commit a criminal offense. After the date of this order, you're not permitted to marry or establish cohabitation in a new relationship, a common law marriage type of relationship with another, without written permission. You must report any contact with law enforcement or an arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. If you must provide your supervising officer with financial information and records, so your ability to pay restitution fees or costs can be reviewed. Now, if you're referred for an evaluation assessment during the time in drug court by probation or the treatment team for any other type of training, counseling, therapy, programming, treatment, etc., you'll submit to that, and if they have a recommendation for any kind of programming, you'll be required to enroll in and successfully complete that. You'll be required to pay the court costs to make payment arrangements with the clerk to do that. You'll pay restitution through the Highland County Victim Witness Office, and I'll let that be determined by probation once you're working. And as I said earlier, you're required to comply with all of the conditions of the drug court docket that have been explained to you and for which you signed indicating that, and those are incorporated by reference. And you're to comply with your treatment team recommendations, or your treatment plan as recommended by your treatment team. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property or place that's under your control or where you're found at any time, any officer of the probation department. And you'll have to sign a written acknowledgement and consent for that at the probation department. There won't be any fine or suspension imposed. Now, you're also ordered to pay the restitution, as I said, of $50 to the Highland County Task Force. You'll be required to pay a service fee, a charge for that. And so my recommendation is save the money up and make one payment so it only costs you one fee, because if you make $10 a month, you're going to pay a fee every month, and I think it's $5, so it'd be a lot cheaper for you to pay it one time with this lower amount. You're also ordered to pay the court costs as a substantive order, and if you don't make the payments that are ordered, or pay the costs as ordered or make payments on them, the clerk can collect those through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, I'm sorry, let me back up. You're not in prison. But if you fail to comply with that order and the clerk cannot collect it, then you could be subject to paying a collection fee if it's referred to collections, or they could levy on any kind of property you have. And if that is not able to pay it, you could do community service in this county and be given credit for each hour you worked in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until it's paid in full. Now, in the event that it's alleged that you have not complied with the conditions of the program and this order, then the probation department will file written notice of that with the court. You'll get a copy. There will be a hearing at which you'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court could terminate you from the drug court docket and sentence you to prison for a period of between 6 and 12 months and fine you $2,500. If that occurs, in part or in total because you committed a new felony while on community control, and you received a sentence of incarceration for that new offense, any sentence that would be ordered to be served in this case could be ordered to be served consecutively as a sentence in the new case. Now, in the event that you do serve a prison term, upon completion of that prison term, it is possible that under the law, the adult parole authority would exercise the option that they have to put you under what's called post-release control supervision for a period of up to 2 years. If they do that, you'll be supervised on the terms they set by a parole officer. And if during that period of time they determine that you have failed to comply, then the probation, or the APA could return you to prison to make you serve as a sanction an additional period of up to, in this case, 1/2 of your prison term for one or more violations. But if you commit a new felony while under post-release control and are sentenced to prison, the judge in that case could also sentence you to prison for committing that offense while under post-release control, in this case, to an additional period of a year. Whatever time is left on that period of post-release control, whichever is greater, if that occurred, that would have to be served consecutively as sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, this completes your case. You're no longer under pretrial supervision, and so those conditions are all lifted, including your house arrest. See the probation office to make an appointment for a follow-up on being transferred to the drug court docket. All right, thank you. All right, case number 24 CR 87, State of Ohio versus Ashley Thomas. Are you Ashley Thomas?
Yes, Your Honor.
All right. Ms. Thomas, we convened this hearing was set at 12:45, and I called your case at 12:45, and you walked in the door about 1:17 or 18. you have an obligation to be on time. I don't care what your excuse is. You need to allow for that. So you need to understand that this is a serious matter, and I'm not going to tolerate this. What's been happening here is a concern to the court. So just so you know that for future reference.
Yes,
now, Ms. Thomas entered a plea of guilty to aggravated possession of methamphetamine, 5th-degree felony. I should say that present on behalf of the state is Assistant Prosecuting Attorney King, and present on behalf of the defendant is Attorney Daniel Witt, although we did put that on record at the beginning of the hearing when the defendant was not present, but it's now on the record for this court for the hearing. All right. So the defendant entered pleaded guilty to aggravated possession of methamphetamine, a 5th-degree felony. The court ordered a pre-sentence report, which I have received, and have each of the attorneys had the opportunity to review a summary.
The state has, Your Honor.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Ms. Witt?
Yes, Your Honor. We also asked the court to follow the joint recommendation while Ashley did not meet the criteria for drug court because of where she lives. We would like to ask that she be placed into treatment and continue her treatment. It's my understanding that she has an appointment later today at the Reach in Greenfield, and then has also been seeing somebody at the Talbert House as well.
Is that an outpatient or an inpatient program?
Outpatient.
I did inpatient in Hamilton County.
Previously, what are you doing?
Talbert House.
Outpatient.
Yeah.
Anything you'd like to say, Ms. Thomas?
Stand up if you do.
Yes, Your Honor. I just completed Addiction Services Council inpatient.
I'm sorry, you're going to have to speak up.
I just completed the Addiction Services Council in Hamilton County inpatient November. I've been involved in Talbot House. I didn't know that my SUD assessment that I had done for Addiction Service Council, I just found out today that the paperwork might not count. So I got a hold of Reach. That's what I was doing before I come here. I have an appointment at 2:15 to see Reach in Greenfield.
See who?
Reach.
Reach, okay. So what's going on in Brown County? Because the notice I got dated yesterday from Addiction Services Council indicated you were released on a holder to Brown County. What was that for?
For child support.
For child support?
Yes.
Okay. All right.
That's where I got involved with Talbot House. They come see me there.
And what is that through what?
Brown County.
What
Talbot
court
House.
order did you? Was that pursuant to court order?
No.
Well, all right. Anything else?
No, Your Honor.
You can be seated. Well, I have some concerns about your behavior, Ms. Thomas. The failure to be here on time is just the latest. Do you have a prescription for Suboxone or Subutex?
Yes, Your Honor.
All right.
Yes.
Well, you didn't show up for your appointment at Reach on March 25th, and you didn't reschedule. You didn't show up as required on March 25th at Probation Department. You called, said you had no ride, and rescheduled the 28th. You didn't show up then. Then I have this, the only thing I have in the file here is the fact that you completed your treatment in Hamilton County on November 25th, as you stated. And they even indicated to you that once you knew what your outdate was from here, which has been for a while, you could get into sober living. And I haven't seen that. and you say you have an appointment tomorrow for REACH. And I didn't quite understand or couldn't quite hear what you're saying about you didn't know about, I'm not sure what you said you didn't know. It sounded like you didn't know about what your assessment was, but I made that pretty clear, I thought, at the hearing. So, you're not off to a good start. Now, despite that, I'm going to give you the benefit of the doubt, and I'm going to order that you be sentenced to a term of 3 years of community control under the supervision of the probation department under these conditions. You're to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times. You're going to report when and as directed and be truthful in all statements that you make to the probation department. You must keep them informed of your residence, place, and employment at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who is an inmate in any of those facilities without prior written permission. Now, because of your conviction, you're prohibited under both federal and state law from possessing, purchasing, owning, or having under your control any firearm, ammunition, dangerous ordnance, and if you do any of those things, then you could be prosecuted for an additional felony. And if convicted, sentenced on that no matter what happens in this case. It's also a condition in this case that you have none of those items, nor any other weapons of any other type. Now, you're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects that are similar to controlled substance drug abuse, nor may you have any instrument, device, or thing that may be used to administer them or prepare them for administration unless you have a lawful prescription for both the device and the substance. You're not permitted to purchase, possess, use, or have under your control any alcoholic beverage or be present in places where they're sold or being consumed even if otherwise lawful. You're not to associate with any co-defendant in this case or any other person that has a criminal record, is a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a criminal offense or to violate these conditions unless approved in writing by your supervising officer. It applies to any family members that might fall within that definition unless you were living with them immediately before this offense was committed. After the date of this order, you're not permitted to marry or establish a new cohabitation relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, or conviction or charge of violating the law not later than the next business day after that occurs. You must provide financial information to your supervising officer so that your ability to pay any fees or costs could be reviewed. If you're referred by the probation department for any further treatment, therapy, counseling, programming, or educational activity of any sort, you're to submit to that. If there's a recommendation for treatment, you're to enroll in and complete that successfully. You're to pay the court cost to make payment arrangements to do that with the clerk of courts. You're going to be required to successfully complete any recommended treatment after evaluation, since we don't have that in the file. Now, by being placed under community control rather than being sentenced to prison, you're deemed to have sent into a search without a warrant of your person, your vehicles, your residence, or any other property that is under your control or where you're found at any time, any officer of the probation department. You'll be required to sign a written release and confirmation and consent to that with the probation department. The court will not impose any fine or any license suspension. Your court cost order is also a substantive order, and if you don't make payments on your court costs or pay them in full as ordered, the clerk can collect that through various means, including levying on bank accounts wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of, if that doesn't collect it, then you could be permitted to do community service in this county and be given credit for each hour you worked at an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied with this order, they will file a written notice of that with the court. There will be a hearing. You'll get a copy of the allegation, and you'll be entitled to have an attorney to represent you. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control and sentence you to a term of incarceration between 6 and 12 months and fine you $2,500. If that happens in part or in whole due to a felony conviction committed while under community control, and you're sentenced to prison in that case, then any prison term imposed in this case could be ordered to be served consecutively to that sentence. If you are sentenced to serve a prison term, upon completion of that prison term, it is optional for the adult parole authority to, if they decide to do that, put you under post-release control supervision for a period of up to 2 years. You'll be supervised under the terms that they set by a parole officer, and if during that period of time they find that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right. Now, Ms. Thomas, as I said, you'd have to start it off on the right foot here. I'm very skeptical. I'm looking at your pre-sentence report. You have had a lot of history and different programs, and I saw that you went to STAR in one case and then got judicial release and then got revoked and sent back. And you have served a term of violence, so this is can be a prison offense. But it seems to me you're not really taking anything that we're telling you seriously, and you haven't shown up for probation. So I'm going to order that you serve 10 days in jail beginning forthwith. I'm going to ask you this question, and you better tell me the truth. They're going to test you when you get to the jail. Are you going to be positive for anything other than Suboxone or Subutex?
No, Your Honor.
You're sure? All right, because if you're lying to me, I'm going to see you again. All right, so you're going to jail now, and it's what I refer to as an attitude adjustment, because your attitude is not good, and it needs to change. And I don't know if 10 days is enough to get that changed or not. Probably not, but at least it gives you an idea that I mean business, and I don't mess around. When I tell you to do things, report when and as directed, you do that. When I tell you you're going to be assessed and you don't show up for assessments, you need to understand, I don't talk just to hear myself talk. I talk for a purpose, and that purpose is for you to obey. And when you don't, you're going to pay the consequences. So that's what this 10 days is. So you're remanded to custody for 10 days. Thank you. All right, this is case number 24, CR 166, State of Ohio versus Rachel Simpson. Rachel Nicole Simpson. And you're Rachel Nicole Simpson, appearing there for the probation department?
Yes, sir.
All right. This is a pre-trial. Ms. Simpson is represented by Attorney Sarah Barger, appearing from her office. Appearing from the prosecutor's office is prosecuting attorney Collins on behalf of the state. Defendant's charged with one count of possession of fentanyl-related compound. This is the first pretrial. Final pretrial set for May 7th, and we have a jury trial set for June the 9th, I believe. And I see that the state has provided discovery, and you've received that, Ms. Barger?
I have, Your Honor.
All right. Your discovery will be due by the final pretrial. And are you anticipating any pretrial motions?
I filed a motion for intervention in lieu of conviction this morning.
Okay. Has your client signed the stipulated questions yet?
She is not. I have not had any contact with my client.
All right. Ms. Simpson, you'll need to get in touch with Ms. Barger. So you call her, or do you have a number you can give her to call you?
I can.
Sorry.
Do you have a phone, Ms. Kennison?
I do, yeah.
Would you give the number to Ms. Barger?
My number?
Yeah.
937. Sorry. Sorry, I got anxiety. 566-9799.
All right.
566-9799?
Yes, ma'am.
Okay.
All right. So she's going to call you here shortly, and need to make an appointment with her to talk to her about your case.
Okay. Thank you. Sorry.
All right. So we will either have another pretrial or perhaps a hearing on intervention once I see the necessary documents have been filed.
Okay, great. Thank you.
All right. Thank you.
Thank you.
Great. Christine Kennison, please. What's that? Oh, okay.
Oh my gosh.
All right, this is case number 25 CR 48, State of Ohio versus Christine E. Kennison. This is a pretrial being conducted by Zoom. First pretrial, final pretrial set for May 7th, and trial is set for June 9th. Appearing on behalf of the state is prosecuting attorney Collins from her office. Appearing from the defendant, on behalf of the defendant from his office is counsel J.D. Wagner. The defendant is charged in a 10-count indictment. Looks like 5 counts of trafficking or aggravated trafficking and 5 counts of possession or aggravated possession. Now, I see that the state provided discovery, and you've received that, Mr. Wagner?
Yes, sir.
All right, and your discovery will be due by the final pretrial. Are you anticipating any pretrial motions?
Not through the first read of the discovery, Your Honor.
You need to dial that down a little bit, Dan. I'm getting a little bit of reverberation. Oh, it's not from there, huh? I've got mine down all the way. I can't go any lower. All right. Might have to go in on Zoom after we're done. Has there been a written plea offer provided?
Yes, sir. And we're late. Sorry, Anthony.
Okay.
That's okay.
That's feast or famine. Either it blares me out or I can hardly hear anything. So, all right. Is your client aware of it, you said?
Spoke to her last night. Yes, sir, Judge.
Okay. All right. Any other matters we need to discuss then?
No, Your Honor.
No, Your Honor.
I see here, Ms. Kennison, that since you've been testing positive, they've recommended you go to a treatment center on the 4th of April. So that is something that the court will expect you to do. All right. Thank you. All right, James Bishop.
I'm finished.
Yes, you're done. Case number 25CR13, State of Ohio versus James C. Bishop Jr. You're James C. Bishop Jr. appearing there from the on the screen marked HCPD.
Yeah.
All right. This is a pretrial. Mr. Bishop is charged with aggravated possession of methamphetamine, a fifth-degree felony. Appearing, this being conducted remotely, and Mr. Bishop is appearing from the probation department on screen, and his attorney is Catherine Hafner, appearing from her office. Appearing on behalf of the prosecutor's office is Prosecutor Collins. This is the final pretrial. Trial set for April 24. I have received a plea of guilty form, Mr. Bishop, which indicates you're going to plead guilty to the charge. I'm going to hold up the first page of this to make sure you recognize the document that I'm working with. You recognize that?
Yes.
Okay. On page 3, about halfway down, there's a sentence that reads, I enter this plea voluntarily, and it looks like the signature of James C. Bishop. I'll hold that up to the camera and ask you if that's your signature.
Yes, sir.
All right. One of the better signatures I've seen in a long time. I used to be able to write that way when I was about 9. All right. Now, Mr. Bishop, did you just sign this agreement this morning or this afternoon?
Please?
When did you sign this agreement?
About 20 minutes ago.
All right. When you signed it, did you understand that it was an agreement to plead guilty, meaning there's not going to be a trial on the 24th and the next step in your case would be a sentence?
Yes, sir.
And before you signed it, did you go over it with your attorney and have her answer your questions and explain things to you?
Yes, sir.
And you feel you had enough time to fully consider the matter before making this decision?
Yes, sir.
Do you feel that you were pressured or rushed in any way?
No.
And you're doing this voluntarily?
Yep.
Now, the agreement says you're going to plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the Ohio Revised Code, a fifth-degree felony. States that you understand that there's a possible term of incarceration between 6 and 12 months and a fine of $2,500 and a possible license suspension of 6 months to 5 years. You do understand that?
Yes.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently, other than on supervision in this case, are you currently on community control, probation, parole, or post-release control for a felony?
I'm on probation and house arrest.
Just from this case, though. I mean, other than this case.
Yeah, no.
Okay. Now, under the law, if you should be convicted and sentenced to prison at any time on this charge, upon completion of that term, it is possible that the adult parole authority would put you under post-release control for a period of up to 2 years, meaning they would impose certain conditions that would be supervised by a parole officer. In the event that you fail to comply with those conditions, they could return you to prison to serve an additional period, in this case, of up to half of the prison term that was actually imposed by the court. However, if you commit a new felony while under post-release control supervision, then in addition, whatever sentence a judge in that new case could impose upon you, a judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time was left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. You understand that?
Yes, sir.
Now, under the law, the court's not required to sentence you to prison for this offense. I can't impose community control or probation. And so instead of going to prison, you would be put under supervision of a probation officer on the term set by the court for a period of up to 5 years. If during that period of time the probation department felt that you were not complying, they would file a written allegation with the court, give you a copy. There would be a hearing. You would have the right to have an attorney at that hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could impose the term of incarceration of 6 to 12 months and fine you $2,500. And if that revocation was due in part or whole to a conviction for a new felony while on community control, and you received a prison term for that new offense, prison term imposed in this case could be ordered to be served consecutively to the prison term of that case. Do you understand that?
Yes, sir.
Judge, can I interrupt?
Yes.
He is on probation for another case right now, other than this.
Oh, is he?
Yes.
Yeah, I've been random drug tested for 16 months. I've been clean.
Okay. But that...
he has a case that's from Highland County
okay.
that...
I see that. You're on probation out of this court. It doesn't have a case number on it, but Okay, so the significance of that is this, Mr. Bishop. If, and again, since there's a community control recommendation, I assume there's not going to be a violation. But if at some point in time you were violated on both cases and were sentenced to prison, then that means that those prison terms could run consecutive to each other. Do you understand that?
Yes.
All right, it looks like that's a 4th degree felony, so that's a possible 6 to 18 months. So you understand that?
Yeah.
All right. Now, what I just said, just so you understand what I meant, was this. Because you're on community control in that other case, a conviction in this charge does constitute a violation of one of the rules that you not commit any criminal offenses, you lead a law-abiding life. So, in the event that you plead guilty here, if the court decided to sentence you to a term of incarceration, then that could also lead to a revocation motion in the other case. It could result in a prison term of 6 to 18 months and a fine of $5,000, in addition to the sentence in this case. You understand that?
Yes, sir.
Okay. Now, the charge in this case alleges that on or about March 22, 2024 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11. So that's the charge we're talking about, the 5th degree felony with the penalties I described. Now, Mr. Bishop, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
And you understand the potential sentences for this offense, including the possible revocation in your other case if you were to receive a term of incarceration. All right. Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with their advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir. No, sir. No, no.
Has anyone threatened you to make you plead guilty?
No.
On page 2, there's a line, a little over a line printed in bold and underlined that reads as follows. Defendant to enter a plea of guilty to the indictment, state defense jointly recommend community control. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the judge, not the parties, and so even though there's a recommendation that you receive community control, you understand that that is not binding upon the court.
Yes.
All right, now, you have certain constitutional rights you must understand before I can accept your plea. First of all, you do have a right to have counsel, and Ms. Hatler was appointed to represent you. Now, that wasn't simply to work the case out, but provide any defense that could be available to you under the law that you would like her to provide. So if you decide that you do not want to do this, she'll continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Bishop, in which 12 people would be selected from a group of citizens that live in Highland County that have been summoned for jury duty on your trial day. After those 12 are chosen, the evidence would be presented, and then that jury of 12 would have to decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you could waive in writing, which means to give up, your right to have a jury trial, and in that case you would have what's called a court or bench trial, meaning that instead of a jury, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that's present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come to court to be available to testify if you want them to, even though they don't want to be here. So what that means is that the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. And then after the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination in this case, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And in fact, no one's even allowed to talk about it except in one situation. If there should be a jury trial and you not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Would you go get the PSI for James C. Bishop, 24? All right. Now, under the Constitution, you are presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So, the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you're not required to present any evidence in your own behalf at trial. You may, but you're not required to. But whether you do or not, the burden of proof will always remain upon the state to prove your guilt at trial by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes.
Right now, originally you entered a plea of not guilty to this charge. That plea denied the allegations in the indictment, denied you committed a crime, and that exercised or invoked all of the rights that you that I just explained for you. Now, in the event that you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea admits the allegation, admits that it's a crime, you committed that crime. And that plea will waive or give up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty. Waive or give up your right to a jury or court trial. Waive or give up your right to confront witnesses against you and to cross-examine them through your attorney. Waive or give up your right to use the power of the court to compel or force witnesses to be in court on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you feel you may have had up until this point in the case. Now, if I sentence you to the maximum sentence or under the certain circumstances, you could file an appeal. Any appeal would have to be filed within 30 days of the sentencing entry being filed. And I don't know if I said this or not, but it also would subject you to being sentenced immediately by the court. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Mr. Bishop? Are you a U.S. citizen?
I didn't hear you.
Are you a U.S. citizen?
Yes, yes.
Okay, sorry about that. Now, do you have any questions, Mr. Bishop, about the charge or the penalty?
No, I'll just...
You understand it?
Yes.
Okay. You have any questions about the plea agreement?
No.
You understand it?
Yep.
Have any questions about your constitutional rights?
No.
You understand those?
Yep.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
You understand?
Yep.
I didn't say this at the beginning, but if you need to talk to Ms. Hapner before we go any further, I can put you and her in the breakout room. It'll just be the two of you talking if you need to do that. Do you have any need to talk to her at this time?
No.
Okay. This is your decision to go forward and plead guilty pursuant to the terms of the plea agreement?
Yeah.
All right. Then as to the charge, Mr. Bishop, which alleges that on or about March 22, 2024, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code, a charge of aggravated possession of methamphetamine, a fifth-degree felony, carrying a possible prison term or term of incarceration of 6 to 12 months, a fine of $2,500, and a license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds that on this day in open court, defendant was advised of all his constitutional rights, made no intelligent and voluntary waiver of the same pursuant to criminal rule 11. Please accept an order filed. Defendant is found guilty as charged. Now, I was just pulled the PSI file from his other case, and that was 23 CR 179, and I think, when was it that you were put on community control in that case? You remember, Mr. Bishop?
It's been almost 2 years ago. It's 18 months.
All right. Officer Benson, is there any new information that you would think would need to update in this file?
No.
I'm asking Mr. Benson, Mr. Bishop. Sorry.
Okay, no.
No, Your Honor, I don't believe so.
Right. Does either counsel feel we need to have a PSI, or are you willing to waive that and we'll go forward with sentencing?
We're willing to waive that, Your Honor, go forward.
All right. You're muted, Ms. Collins.
That's fine with the state, and I would note it's actually been closer to now than 18 months ago. Yeah, it was just January of 24.
All right. Well, that's about 14, 15 months, something like that. So, okay. All right. Then it is the order of the court that the defendant, well, I'm going to ask you, anything further from the state regarding the sentencing?
No.
No, Your Honor.
Ms. Hatner?
No, Your Honor.
And do you have anything else you'd like to say, Mr. Bishop, before I pronounce sentence?
No, I'm just trying to get through this.
All right. Well, is the judgment order of the court then the defendant being is hereby sentenced to the term of 3 years of community control under the same conditions previously ordered. In the other case, but I'll go over those with you briefly, Mr. Bishop. You're to obey all laws of all jurisdictions, conduct yourself in law-abiding manner at all times, report when and as directed, be truthful in all statements you make to the probation department, keep them informed of your residence, place of employment at all times. Can't change either without prior permission. Can't leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate in any facility without prior written permission. Because of your conviction in this and the other case, you're not permitted under either federal or state law to purchase, possess, own, use, or have under control a firearm, ammunition, or dangerous weapon or dangerous ordinance. And if you did that, that would subject you to being prosecuted for a felony under both federal and state law. You're not permitted to have any of those items as a condition of the community control in this case, nor any other weapons of any type. You're not permitted to purchase, possess, use, or have under control any kind of a controlled substance, drug of abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has an effect similar to those. Unless you have a lawful prescription, you also have to have a prescription for any device that may be used to administer, prepare for administration, or use drugs. You have to provide copies of those prescriptions within 24 hours of receipt to your probation department. You're required to submit to drug testing when and as directed. You may not purchase, possess, or have under control any type of alcoholic beverage or be present when they're sold. You shall not associate with anyone who has a criminal record as a member of a gang or other criminal group, or any person has in the past or could in the future influence you to commit a criminal offense or violate these conditions. Unless proved in writing by your supervising officer. After the date of this order, you're not permitted to marry or establish a new relationship, a cohabitation relationship with another without written permission. You must report any contact with law enforcement or a arrest, citation, conviction, or the charge violating the law next business day if that occurs. If you're referred for evaluation or assessment for any further treatment, therapy, counseling, training, or programming, you'll submit to that. If any program is recommended, you enroll in and successfully complete that. You're to pay the court cost and make payment arrangements to do that. Now, is he currently in any kind of treatment or aftercare?
Yeah, I'm in recovery counsel, outpatient.
All right. So then you'll be required to comply with the TRC, stands for Recovery Counsel, aftercare or outpatient treatment program. Now, by being placed on community control rather than being sentenced to prison, Mr. Bishop, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles owned by you or used by you, or any other property places under your control where you're found at any time by any officer of the probation department. And you'll sign a written notice or acknowledgement and consent to that. be no fine or suspension of license here. And if you don't pay the court costs, the clerk can collect that through various means, including levying on bank accounts, wages, or other earnings you may have. And if that doesn't collect it, then you could be required to do community service in this county and be given credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. In the event the probation feels that you're not compliant with this order, they will file a written allegation of that with the court and give you a copy. And if you'll have a hearing in which you'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court could revoke your community control in both this and the other case, and you could receive a sentence in this case of 6 to 12 months and a fine of $2,500. If that occurred because you committed a new felony while under probation or community control, then any sentence you receive in that new case could be ordered to be served consecutively as a sentence in this case. Now, in the event that you do serve a prison term, it is possible upon completion of that the Adult Parole Authority will place you under post-release control supervision for a period of up to 2 years. If they do and they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to half of your prison term. Well, 9 months is the maximum, but half of your prison term for one charge. One violation is a 9-month possibility, but there's a cap or limit of half of any prison term that was imposed for one or more violations. However, if you commit a new felony, then in addition to whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. If that occurs, it has to be served consecutively as a sentence in the new case. You understand that?
Yes, sir.
All right. Is there anything further from counsel?
No, Your Honor.
All right. That completes your pretrial supervision in this case. The case is completed, so you're released from house arrest. You just continue to comply with the conditions that you've been doing with your other case and your probation officer. And there'll be no action taken in that case since I went ahead and granted you community control. There's no need to do that. But the next time, if there's another time, you will probably not be so lucky. All right. And thank you.
Thank you.